Call the list. Supplemental list, cess admission item number 1.
My lord, the petitioner is one of the petitioner in the previous read petition, my lord, in which this honorable court has ordered to allot a land in favor of all the petitioners, my lord.
What's the date of your representation? Annexure 12?
My lord,
Ten 2022. All right. The petitioner's representation, academic sheet 12, will be examined by the Tahsildar.
my lord,
All right. And after notice to the petitioner and giving her a hearing, a reasoned order should be passed not later than 1st May and communicate to the petitioner within a week thereafter. The court clarifies it as not expressed in the matter.
my lord,
You've disposed of asking them to consider your representation.
my lord.
Item number 2.
My lord, in this case, my application for grant of sawmill license is pending before opposite party number 4.
This is not specifically a PIL because he's asking for
For himself.
My application, my lord, regarding grant of license, my lord.
That's right. Let's go for the single judge. So
Pending
this is
before
not a public interest litigation matter. List before the roster bench. We'll have it on Friday itself. On Friday.
Item number 3.
May I please your lordship, my lord? My lord, before this writ application, I filed a writ application before this honorable court, that is annexure 2, my lord. As per that writ application, the honorable single judge has directed to the Tahsildar to initiate an encroachment case against the encroachers, my lord. And accordingly,
You can't file a division bench
my lord,
petition for implementing some Tahsildar's order in the OPLE Act. This is all a novel way of doing things.
my lord, my humble submission before your lordships, my lord, before this writ application was listed before the honorable single judge, my lord. But that writ application was referred to your lordships, my lord.
No, this is, you say this simply asks for implementation of order of a Tahsildar in an OPLE matter. We'll stop this. You want to withdraw this, you withdraw this.
My lord,
For implementation of Tahsildar's order, you don't file a writ petition like this, sir.
my lord,
even if before the
Becomes
honorable single
the High
judge.
Court will become the executing court.
no, my lord, my humble submission before your lordships, my lord, as per the annexure 2, my lord, annexure 2, the honorable single judge has directed to Tahsildar to initiate an OPLE case, and the Tahsildar initiated
you see-
OPLE case, my lord.
Yeah, the OPLE
Only to-
case arose from an order of a single judge. Full stop. This is not a matter for public interest litigation. Full stop. You can file a contempt or something, I don't know.
Yes, contempt or you
My lord,
approach
there-
the collector for necessary.
No, my lord, there is the contempt is not maintainable because
All right, then you go approach the collector.
my lord, contempt is.
The High Court cannot be converted into an executing court for orders of the Tahsildar. Full stop. Leaving it open to the petitioner to seek other appropriate remedies, the petition is disposed of. All right.
Item number 4.
My lord,
Same
4, 5, same, my lord.
Same.
3, 4, and 5.
Item number 6.
May I please, my lord? My lord, kindly have a glance to running page number 15. My prayer. May I read, my lord? Here, my lord, the prayer has been made to direct the opposite parties to take immediate steps for effective handling of depression and stress cases among the police personnel in
You
Odisha
file a
police.
representation, sir. Let them consider it to be
There
representation.
is a representation.
Yes, my lord. It is representation is at running page number 28, my lord. Both to Home Department as well as the Director General of Police.
Let the Director General of Police.
And my lord, if my lord will permit me, I just want to place a Supreme Court order, judgment, my lord.
No. Let them first
Because-
consider it. But let them first consider it. Petitioner's representation dated 5th September 2022, bracket annexure 4 series, shall be examined by the Principal Secretary,
No,
Principal
my lord, Director General of DG.
Director General of Police.
Director General.
And after hearing the petitioner on a date to be informed to him at least 10 days in advance, a decision be taken thereon and communicate to the petitioner within a week of it's being taken. The court clarifies it has not expressed any view in the matter. Petition is disposed.
Deeply obliged, my lord.
My lord, your lordship directed that the petitioner will be heard
Yeah.
in the matter. There is nothing, it's,
He may want to explain
Yes, sir.
what he has in mind.
Item number 7.
May I please indulge? The limited prayer of the petitioner, my lord, is his second appeal has been dismissed by the tribunal for non-appearance. What has happened in this case, the petitioner's factory, my lord, due to loss was closed for a long time. And unfortunately, it was served on someone else. The fact of the case, my lord, is even though if your lordship would kindly turn to page 11, my lord, the annexure 1 of the tribunal's order, page 11, paragraph 5, my lords. So entire demand is because of wanting of C forms, my lord. Now, all these photocopies of the C forms were produced during the first appeal stage, my lords. Since I could not appear, my lord, I could not produce the originals before the tribunal. My lords. My simple prayer, my lord, before your lordship would be to give me another opportunity before the tribunal so that I can file the originals, my lord. The photocopies are already there on record. I'll only file the originals, my lord, and then
All
the
right.
tribunal will pass necessary.
All right. But you should have filed a revision, no?
Yeah, exactly.
No, my lord, sir. Here, my lords, there was no question. My lord, with great respect, my lord, I felt, my lord, there was no question of law arising, my lord, because it
No.
was.
For valid reason, if you were unable to be present.
My lords, you may
This
consider.
is the short ground on which the impugned order dated 12 June 2017 of the Orissa Sales Tax Tribunal, dismissing the petitioner's essay number 28 bracket C of 2013-14 has been challenged is that it was passed in the absence of the petitioner. Paragraph. The writ petition narrates the circumstances under which counsel with the petitioner was unable to be present before the tribunal when the aforementioned appeal was taken up. Full stop. Apparently the petitioners.
Your lordship can convert it into STREB and pass the same order, your lordship.
Doesn't make a difference, sir.
Your lordship, but
All right.
This is not.
that's right.
It is explained that the petitioner's factory was not in a running condition. Correct. Having considered submission of counsel to the parties, the court is of the view that the petitioner ought to be given one more opportunity to pursue the appeal before the tribunal. Full stop. Accordingly, the impugned order is set aside and essay number 28 bracket C of 2013-14 is restored to the file of the tribunal, where it will be listed for hearing on 10th April 2023. Full stop. On that date, the petitioner will ensure presence through counsel. The tribunal is requested to proceed afresh with the said appeal and endeavor to dispose it off as expeditiously as possible. The petition is disposed of.
My blessed, please.
Item number 8.
My lord, entry tax matter that may be added to tomorrow list. Tomorrow entry tax interest matter.
Take list tomorrow. All right.
Obliged.
Item number 9.
Item 9 and 10 not present.
Not dismissed.
Item number 11. Item number 11.
None appeals dismissed. Oh, Passover. Let's pass
it's a
over.
new matter.
Passover once.
Item number 12.
More defect.
Yes, yes. The office report has been perused. The correction we carried out. All right.
Item number 13.
13, my lords, I have served the copy. That was the defect. And my lords, this is first appeal order on challenge on GST. Your lordship may pass is
20%. Same thing. 10%. Date you have to give us 11th September.
Item number 14.
The question has been framed at page number 7, whether in the facts and circumstances of the case, the learned ITH are not accepting the fact that the SIC is in a business of education.
Limitation, sir. 221 days, steps not taken.
No. The appeal is for it's 2, 3, and 5, and 3 defect has been removed. And there is a corner period.
One of the defects is limitation, sir. You have not filed application for condition of delay.
Yes, I have given that.
Where?
That in paragraph 7.
No, application, sir. You have to file an application for condition of delay.
Condition delay, in one case, it is defect has been removed. In 2 cases, delay is there. But the same fact are there, same case is there. I have given that the appellant, at page 9, that appellant received the order of the Honorable ITAT on 17/2/2001, but considering the outbreak of novel virus, lockdown is being enforced by the government of India and the state government due to non-availability of public mode of transport for the, it is Supreme Court decision that is mentioned in the stamp reporter. In one case, in 2 cases, he is not mentioned. 2 and 3 and 4. ITAT 2, 3, 4. 2, 3, 5 million.
Achha, 10, 11, 11, 12, we already filed appeals.
Yes.
Where?
It is 2, 3, and 5.
Oh, it's all here.
Yes. 5 is at 16. 3 is not listed.
He's not saying that. Okay, come on, merits. What are the, let's see the merits. Whether we should interfere at all.
The past that is against me.
Computer Academy, sir, why are you chasing?
And ITA 154, 152, 153 of 18 in the same case.
Same party.
Yeah.
Orissa Computer Academy. That's so.
Right, same order.
2, 3, and 5.
All right, same order. If there's an ID, delay is controlled. If it's not, simply ignore it and say.
2, 4, and 5.
No. 4 is Guru Nanak Dev.
4 is different.
3.
Item number 15.
It's,
No, 14 also. Give us item numbers, so that's easier.
Item 14, 16.
Item 15.
But the question is framed at page 7. Whether in the fact and circumstances of the case, the appellate tribunal was justified in holding that the SCC was entitled to the relief under section 80G when the main object of the established construct, maintain and run a Gurudwara at Puri, providing for regular daily Seva Puja according to the Sikh religious custom tradition established in India, which is in contravention of section 80G 5 and 6. And whether on the fact and circumstances of the case, the appellate tribunal was justified when the fresh material or evidence furnished before the Honorable ITT were not available for the CIT exemption. And whether on the fact and circumstances of the case, the appellate tribunal was justified.
No, let's read the
Yes.
tribunal's order, sir. It's a long order. So let's see that.
Tribunal order.
Sir, the Gurudwaras are the only persons helping people in all your disasters. If you can't grant it to them, whom are you going to grant it to?
That is why the CIT exemption rejected the ATG application.
Correct. No. This is correct. The reasoning is of the tribunal seems perfectly correct. And they followed their own Lucknow orders and other orders. Chandigarh, of course. I don't think we should interfere. Sir. This appeal by all correct. Yeah, this appeal by the revenue challenges an order dated 24th May 2021 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack bracket IT80, allowing ITA number 384/CTK/2018 filed by the respondent against an order for Commission of Income Tax bracket exemptions bracket Hyderabad dated 29 June 2018, dismissing an application filed by the respondent under section 80 capital G bracket 5 bracket small Roman small 6 of the Income Tax Act 1961 bracket Act. Paragraph. The short ground for consideration before the IT80 was whether the respondent, which is admittedly a religious charitable public trust, fulfills all the conditions for grant public approval of the exemption applied for. Paragraph. The tribunal, the stand of the department was that the respondent was engaged in single quotes religious activities, unquote, and therefore violate section 80 capital G bracket 5 bracket small 3 of the Act. Stop. The tribunal noted that the aforementioned clause 80G bracket 5 bracket 3 stipulates that, open quotation, the institution or fund is not expressed to be for the benefit of any particular religious community or caste, unquote. In this regard, the tribunal pointed out that the CITE had in the instant case not rendered any finding regarding the genuineness of the activities carried out by the respondent. Stop. The tribunal was shown, the IT80 was shown material that demonstrated that the respondent trust provided food to the pilgrims and tourists visiting Puri without any discrimination based on gender, caste, creed, or religion. It had also carried out the development of the park and plantations for children and citizens of Puri. It had undertaken relief and rehabilitation work in Puri during the Fani cyclone. This by itself proved that the respondent trust was carrying out activities that were truly charitable and not for any particular religion or followers of a particular religion. Paragraph. The IT80 is also referred to a large number of decisions of coordinate benches of the IT80 at Nagpur dealing with similar applications by other charitable institutions. The IT80 was satisfied that the respondent trust, open quotation, is not conducting activities only towards Sikhs, but also for the benefit of all human beings belonging to all religious communities and all castes without any discrimination and not working for the benefit of a particular community, unquote. Having heard Mr. Chimankal and his senior standing counsel of the department and having carefully perused the orders of the CIT bracket E and the order of the impugn order of the IT80, the court is satisfied that the IT80 has committed no error in reversing the order of the CIT bracket E. And directing him to grant the approval under section 80 G bracket 5 bracket small 6 of the Act. Paragraph, no substantial question of law arises. The appeal is dismissed.
Item number 17.
Lordship, item number 17 to 31 pass over.
All
So, sir,
All right.
sir, will be
17 to 31.
17 to 31.
All right.
Oblige.
Item number 32.
None of those dismissed.
Item number 33. 33.
None appears dismissed.
Item number 34.
Same order.
Item number 35. Item 35.
Item 32, you wanted to withdraw.
32 dismisses withdrawn. All right. 35 call to
Item 32, I was.
Sir, we've already dismissed as withdrawn after your hearing your submission. Item 32 has been dismissed as withdrawn.
My lord.
Call out.
35.
Ah.
Item 35.
None appears dismissed.
Item number 36.
For if I may please your lordships, my lord. My lord, the petitioners are villagers. My lord, wherein they have challenged the order of the RDC, wherein, my lord, without any powers being conferred under the OMCC rules or otherwise, my lord, the release period has been extended indefinitely without a prescribed time limit. Your lordships may kindly have page 27.
Isn't that strange, Mr. Mandi?
Yes, that is already closed. That RDC has already passed the order and it has been.
No period.
No,
How can it no period be fixed?
No, the RDC has extended the period proportionately in respect of
till
the
when? Till when?
unlifted materials.
My lord, this is sand, my lord. It is not that they have to take it out. It is available. My lord, the opposite party, the private opposite party, my lord, failed. My lord, it is his case that he has failed to pick up sand.
And
My
that
lord,
has already been decided in many writ applications. Your lordship has decided that he is entitled to extension if at all it is found that
Till what period? Extension by 6 months.
period
1 year?
will be computed by the Tahsildar. I am getting instruction.
All right, you better take.
My lord, may
So one of
kindly.
the grievances made about the impugned order dated 28/10/2022 passed by the Revenue Divisional Commissioner, bracket Central Division Cuttack, by the petitioner villagers is that no time period of extension of release has been indicated therein. Paragraph. You say, Mr. D.K. Manthi, learned AG, states that he will seek instructions and inform the court on the next date. 4th April.
My lord, there's some urgency. My lord, may kindly have a visualization on
There
one
is
more.
no urgency at all. Who are you? Why you are creating all sorts of, because they are
My lord,
only filing cases one after the other.
Let it be
And in many cases,
Your
your
lordship-
lordship has disposed of.
My lord, may just one moment, your lordship may permit me. My lord, why I am concerned is that, my lord, your lordship would appreciate, my lord, the collector has held in his order categorically that your lordship may kindly see page 21 for a moment, my lord. Your lordship may kindly have a glance at page 21, my lord.
Yes.
Your lordships would see that, my lord, on the first part, on being directed to the sub-collector Bhadrak, submitted report
All
later.
right, 27th March. All right, 27th March. All right.
My lord, may I pray for stay of the order?
No. What is this?
I'm grateful, your lordship.
Item number 37.
My pleasure, lordship. Well, the matter relates to the organization of a mela in the school premises, my lord. But your lordship may kindly come to annex to
Saraswati Mela. It's
Saraswati.
all over.
My lord,
This is, when is the Saraswati Mela?
my lord, your lordship may kindly come in the school premises.
No,
my lord, in
when
the-
is it, sir? When is it going to be conducted?
my lord, it was going to be conducted from 7th to 12th of this month. My lord, in the meantime, my lord, Your Lordship may kindly see, after filing of the writ application, my lord, there was another mela in the name of Dhumusa, the tribal communities, my lord. And in that mela, my lord, huge gathering is there. It is in the school premises. Now in March, my lord, the examination of the matriculation students is going to be held. Your Lordship may kindly see, after filing of the writ petition,
Melas for how many days?
the mela is to be held for 10 days, my lord. My lord, your Lordship may kindly see, on earlier occasion, my lord, this similar matter was also before this honorable court. Your Lordship kindly see the order of this honorable court at Annexure 4, my lord, page 22.
No, how is it in the school? Just come to that page 22.
My lord.
Simply says NOC for organizing it at Uddala.
My lord.
Where is it saying school?
My lord, Annexure 2 is the order of this honorable court, page 18.
No, sir. First,
no.
let's come to what you're agreed by. Come to page 22.
Impugned order,
My lord,
Annexure 2.
page 22, my lord.
Where does it say it is in the school?
My lord, but it is in the school premises. It is going to be held in the school
Where
premises.
does it say, sir? Please.
Yes, my lord. Your Lordship may kindly say, I am filing an additional affidavit because after filing of this writ application, they did not allow for organizing Saraswati Mela, but they allowed for organizing Dhumusa, but so that this Mela can continue in
You're
the
not
school
answering
premises.
the question, sir.
My lord.
If you don't want to answer the question, we'll simply record that you refuse
No,
to
my
answer.
lord, I am sorry, my lord, I could not follow.
Come to page 22.
My lord. Yes, my lord.
Tell us in this entire page 22, where does it say that this Mela is going to be organized in a school?
My lord, there is no mention in this letter, my lord.
All right. Where do you get it that the Mela is going to be in the school? On what basis are you saying the Mela is going to be held at the school?
My lord, that is their application. That is their application, and
Sir,
presently, my
you have to
lord.
show us a document
Yes.
whereby permission has been granted to hold Mela in a school.
My lord, I am filing the additional affidavit, my lord. Your Lordship may kindly see. Just. My lord. Your Lordship may kindly see the record of right where the school situates. Two plots are there, plot number 197 and 199.
We've gone to something else now.
My lord, now they have permitted to organize the Mela on plot number 199.
All right. Now you have your additional affidavit.
My lord.
Come to page 4.
My lord.
Where does now in this letter, where does it say it will be in the school?
Same letter.
My lord, plot, yes. My lord, plot number 199. Your Lordship may kindly see in the middle of the letter with reference to the subject cited above. I am to say that once Sri Bhaskar Chandra Malai, Honorable ML, Uddala Com President, Kaptipada Subdivision Level, Uddala Mahotsav Committee, Uddala has requested for necessary permission for extension to organize Dhumusa over plot number 199 in Khata number 71 of Mauja, Uddala town. Now, your Lordship may kindly come to
page. No, he's asking, the ADM is asking for the views of the Superintendent of Police. That's all.
My lord, on this basis, the permission is granted. My lord.
Where is it granted, sir? Please show us. Where is it granted? This is 6th February. He's simply writing to the SP saying, please consider submit your views.
My lord, they have permitted, my lord.
Where is that order, sir?
They have permitted, my lord.
Where is that order? And where do we know that plot 199 is a school?
My lord, annexure, my lord, the record of right I have enclosed, my lord.
I think this is all.
The record of right is at annexure 16, my lord. It is recorded 16. In the name of, yes, annexure 1, page 16, my lord. Page 16 is the record of right. There are two plots. There are 3 plots. In one plot, the DI office is functioning, and another 2 plots are there. And over that plot, the school and its campus is there.
199. We don't know what it is, sir.
Page 16, my lord, of the writ petition.
Is it in a playground in a school, sir? We don't know. Is it in the school? The fair will be held in a playground, right? I don't know. I mean,
I also don't know.
I'm also,
but
I don't want to hazard that what the practice in Odisha is. Normally, in all other states, when they talk of Mela, it will be in an open playground kind of an area.
Playground.
No, There are other grounds, my lord. It is in the school premises, my lord.
What is premises, sir? Premises has buildings, it has
Yes.
playground. What are you talking when you say premises?
Well, as your lordship, it is building and the playground of the school.
So in building inside the room, Mela will be held.
No, my lord. No.
Just please make your submission
yes.
properly, sir.
Yes, my lord.
When you
It is-
simply say it's going to be held in a school,
Yes.
what does it mean?
Please-
Is it a school playground or is it inside the school building?
Well, it is in the school playground, which is in the
So
campus
why
of the
is the
school.
playground Mela going to be affecting classes? It won't affect
Well, in the
classes.
campus of the school, your lordship, kindly see now the examination time of the
They will
students.
be in the playground for exam or they'll be in the classroom?
Well, it is a huge gathering is there. More than lakhs of people are gathering. 10 days
Lakhs of
Mela.
people.
Well,
In
10
Uttara,
days,
the
Sir,
population
that
of
10 days is
Uttara
not
is
there. This
10,000.
NOC talks of 2 days or something.
No,
They already
5th to 7th.
in the additional affidavit, they have,
Anyway, this letter from 5th to 7th February is infructuous now.
yes. 5th to 7th, my lord, the Dhumusa, the next letter, your lordship, may kindly see.
Sir,
But
my
initially-
calendar says
yes,
today is 8th February. I don't know what your
yes,
calendar says.
Initially, it
No,
was
no, today is what, which date, sir?
8th, my lord.
Is it beyond 7th or before 7th?
Well, after 7th, they have extended at Annexure 6. That is my, well,
Annexure
I want to
6 is
bring it
not
to your lordship's
impugned, nor
notice.
it has been introduced by amendment. Amendment has not been allowed. Today is filing an affidavit, mere affidavit. They have never challenged the so-called Annexure 6, the subsequent order, what my learned friend is saying. The challenge in the writ petition is that date is over.
my lord, your lordship, may kindly see earlier order of this honorable court, my lord. My lord, similar, for organizing Saraswati Mela, the matter was before my lord's, my lord. My lord directed that the Saraswati Mela shall be organized at any other place other than the school premises, my lord.
Premises is again a problem, sir. Premises means it has buildings, it has playgrounds.
The playground
You can't simply say premises.
well, the plot number 2, plots are plot number 197 and 199, my lord.
And what is the hours of this Mela? I'm not clear. Sometimes it could be after school hours.
Must be in the evening hour. And
Ah,
your lordship will
entire-
see,
entire-
there are two plots, 197 and 199. As per page 17, these are of the school. So 199 is a different plot,
Vidyalaya Gruha.
197
No,
plot.
no.
What
One-
is written, school Vidyalaya Gruha or Hata Avastita. Hata means that
Premises.
my lord says it is
Premises.
within the premise.
Both the
a
plots.
Playground or
Playground.
open space.
That is obvious.
And in this premise includes both
Sir,
building
if it
as
is
well as.
if it is after school hours, it won't affect any school.
No, my lord, it is not after, my lord, hundreds of shops have, my lord, are
Show
to
us
be.
photographs. Show us photographs. Show us what is happening. You're from that area?
My lord,
Are you from Uddala?
no, my lord, I am.
You have some counterpart in Uddala who's sending you this matter.
Yes, my lord.
Ask him just on a mobile phone. He can WhatsApp. He can give you photos.
My lord, let him first introduce this document, Annexure 6 in the writ petition,
My lord, this is.
and make a prayer to quash that. Then only he will be eligible to say all
No,
this.
my lord,
Because
why-
that letter is not
No,
impugned.
that formality, my lord, that formality
No
at present,
formality,
my lord.
that is the procedure.
No, after the writ petition was filed, my lord, I brought it to the notice of the authorities that.
So first two things, show us what photograph, where
Yes,
this Mela is being
Yes,
held.
my lord, yes, my lord.
Second, hours of the Mela, sir.
No, it is
Mela
not
is-
second hours, my lord, it's the entire day, my lord.
What is entire day?
And in the evening cultural program, my lord, hundreds of shops are, my lord, open at the time
Sir,
of Mela, my lord.
If the
And
cultural
now
program,
they have
one
opened.
minute, sir. If the cultural program is in the evening, there will be no classes. All right.
Yes, my lord, I could follow. I am highly obliged, my lord.
So
Well,
that is not going to be a distraction for
Yes.
children.
Had it been in the evening, my lord, there would have no problem, my lord. It is in the daytime and evening.
No,
my
you're
lord.
just adding things.
No,
You don't know.
And this is going on for last
Also,
4
Mela,
days.
your lordship, 10
this-
days, Mela, your lordship
At
can.
this hour at 11 o'clock,
My lord.
you can have photographs and. on
Yes,
your,
my lord. Yes, my lord. Within half an hour, I can get the photographs.
Okay. Show us. Pass
My
it.
lord,
Your lordship,
let
your
me
lordship may take
submit
up
one
at
thing.
12 o'clock. my
This
lord.
type of litigation in all the places, there are two groups. villagers. And if one group supports today, other group will. This is the outcome of all these things. So Lordship may see the photographs.
But this may be the outcome, Milord. What Milord, the authorities should take into consideration that is the school premises and mark.
Must be a very big premises.
Yes,
There is a
yes,
field there.
yes, yes.
In the field,
And in the month,
very small
I'm
place.
presuming that no such mela has ever happened to Udala in the last 10 years.
It was
No, tell me, just seriously tell me,
Yes.
no such mela happened in Udala in the last 10 years.
Milord, for COVID only.
This is that Magh Mela, no? What Mela is this?
He is saying lakhs
not
of
Magh
people.
Mela. Not Magh Mela. After Magh Mela is Saraswati Mela. And Dhumusha is there.
In India, every weekend we have Mela.
Traditional Mela Dhumusha.
Every district will have different melas. So in people of Odisha can be kept busy through the year.
Well, only for 2 years for the COVID-19 Mela, the Mela was not there. Thereafter Mela, they ignored this honorable court and but now conducting the Mela in the school premises. Although there was restriction by this honorable court not to organize the Mela in the school premises.
You get us those photographs. Something you show us. Some material. Pass over.
Well,
Item number 38.
Your Lordship, item number 38, the IA might have been infructuous, Your Lordship. Lordship by
Correct. If infructuous is disposed of. All right.
Item number 39.
Lord, it is a case of, by your Lordship's order, I had paid a certain amount of money, which by your Lordship order became refundable under the 10A penalty. Now, they have not given my interest on that. So the question is that there should be a demand of interest, and I'm filing this petition for demand of interest. And I'll give a copy to my standing counsel.
Is there a statutory requirement to pay you interest?
No, there is no statutory requirement, but there is a...
Then you file a suit, sir. File a suit.
No, suit is not maintainable.
Why?
No, suit is not maintainable.
You want money from the government, why is suit not maintainable?
No, because in this case, unless there is a grant of interest, is what provides under the Act, Orissa Sales Tax Act on Section 14, but that must be an order of direction by the court to give interest. Then only they will. I will have to be able to apply. But let them file it.
No. At the time interim order was passed, you should have asked for that relief.
In an interim order, we get satisfied with the interim order. At the time of relief.
No, not OST. Under the OVAT Act. Under which provision?
Under the CST Act. Penalty under the CST Act.
Okay. Let's see the CST Act. Which provision?
Section 10A is in lieu of prosecution, and the prosecution was purported to be under Section 10B. But which provision, according to you, provides for payment of interest? Tell us that. No, Section 14 of the Orissa Sales Tax Act.
So that act is gone. Which period are you talking of?
The reference is there because I have to operate the Central Sales Tax Act. I have to refer to the Orissa Act. The mutandis application were there. That is exactly what my Mr. Dwivedi was arguing before your Lordship.
Now we've gone to something else. All right. Which provisions are? Tell us.
Section 10A.
10A?
10A of the Central Sales Tax Act. You also got it?
This is penalty, sir.
This is the penalty. As against the penalty order, I came to your Lordship, and your Lordship granted an interim stay that you, on condition of your payment of 6 crores, you will be getting a stay. Then ultimately, your Lordship found that the person who had imposed the penalty had no authority, and therefore your Lordship quashed the order.
When did we quash it? When did we quash it?
Well, I have mentioned here in the petition.
No, where's the order? 6/9/2018. No, that's not our order. Which order did we quash it?
WPC number 1412 no, WPC number out of the total difference amount and the cost title will, you don't. Your lordship may call it next way.
It has 10/5/2018.
It is on WPC number 25242725 of 2011 on 11/5/2018.
Where is that order, sir?
I have some difficulty. Your
So,
lordship.
no, so according to you, I'm understanding, if I understand you right, in that order dated 11th May 2018, we had asked them to refund it to you with interest. Is that correct?
Yeah, no, they have only said that the order is quashed because
then you should have filed and you should have asked that court to grant you interest.
No, I'm Orissa High Court, I'm praying for your
No, what is this? I don't understand. That proceeding is over, that order is over. Whatever you should have asked in that order, you should have asked in that order.
No, I'm asking here now.
No. You can't. Matter is over, sir. You can have another writ petition just for this. No question.
What I'm submitting, you may call this tomorrow or any other date. I'll be given.
No. I'm sorry, sir. Actually, the whole proceeding seems to be misconceived. If you are aggrieved, saying, sir, when you quashed the order, you did not ask for interest to be paid. You simply quashed the order. Therefore, I'm aggrieved by the order. You know where you should go when you're aggrieved by that order. You can't file another writ petition in the same court. That's misconceived.
Come in a writ petition.
No, it's totally misconceived. That cause of action is over. That order was passed by this court. You are probably aggrieved that order does not give you interest. If you had prayed for interest, maybe the court could have said one way or the other. If you forgot to pray for interest at that stage, you can't now suddenly wake up and say, oh, I should have prayed for interest. Let me file another writ petition for that.
Your lordship, call it on Monday, I'll give it.
No, sir. If that order
I'll be able to give your lordship a reply on Monday. If your lordship call it on Monday.
At the request of Mr. Manthi, list on 9th May.
9th May. Well, I'll give a note also before that.
Sir, please, if that original order did not ask that interest be paid, we cannot entertain another writ petition just for that. In fact, you'll have to make out your case in probably civil proceedings. It's a pure money claim. So I don't see how we can entertain another writ petition for this.
But I think I'll be able to satisfy your lordship.
Item number 40.
Item number 40, may I pray for Passover, my lord?
All right.
Item 41.
None appears dismissed.
Opposite
party. He wants the opposite party. All right.
Item number 42.
But item number 42 to 45, the lordship have passed similar order in other cases. Here I am challenge the order of the revisional authority remanding the matter for initiation of the press proceeding and after the statutory period. That's why the lordship have disposed of this matter. I think that.
Same order.
Same order.
The date has to change. Oh, date is also same. All right, same order.
Date is the same
Yes,
revisional authority. Everything is same.
Correct.
Item 42, 43.
42, 45, yeah, up to 45.
Up to 45. 44 is from Chandan Automobiles. Anyway,
44 is.
44 is different.
44.
No, 44 is also
is the same.
Oh, I see.
44 is same.
All right.
Item 46.
Your lordship may permit me to appear in this case.
All right. You say the name of the earlier counsel be removed and Mr. Kerr's name is shown.
Yes. In absence of a tribunal under the GST Act.
10%, 20%.
No, I've already paid the entire amount. That's why.
Okay.
That's why I've given your lordships that order which you have passed.
That variation.
My lord, my lord. At page 44 of the brief, my lord, I
All right.
paid the entire amount of 76 lakhs.
All right.
Page 44.
All right. Same, 23rd August. All right.
Obligement.
Item number 47.
Petition, my pleasure, Lordship. Here some defects, my lord, second copy not filed and copy not served. But the case is, my lord, there was a GST on minor mineral, my lord, sand mining. Demand under annexure 1, Your Lordship.
All appealable demands, sir. All appealable demands. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies challenging the impugned demand in accordance with law. Permitting the petitioner to do so, the present petition is disposed of. Same the next matter.
Lordship, in case of, instead of dismissing, disposed of, Your Lordship.
Yes, we always say disposed of, sir.
Lordship. Obliged.
Statistical purpose. These are all statistical purpose matters.
And also your lordships, despite in this manner, they're not serving the copies also to us because ultimately this will be the order.
Anyway,
Oh,
fees is not affected. Whether he may serve or not. Entire day, only one piece.
One piece.
Item
Yes.
49.
May it please your lordship.
Yes.
My lord, I am appearing through VC.
Yes.
My lord, I am appearing on behalf of Mr. Jayant Kumar Das is out of town. My lord, in this case, there are two defects. One copy has not been served and another legible copy.
This out of town is no longer an excuse. You should say he's out of a laptop, out of a PC,
No, my
out
lord,
of
that
the
is-
phone camera.
That is the instruction.
You're yourself in front of a camera.
My lord.
Ah.
My lord, there are two defects. In the meantime, I'll remove the defects. The lordship may kindly adjourn it to some other day.
Rejection order is what? All right, list on 16th March, defects will remove in the.
Item 50.
Grateful.
May I please, because here assessment made under section 74 by annexure 2 minutes. Because the only issue was minutes, there is disparity between the output supply disclosed to the EU bill and that of GST and 3B. Because I filed a rectification application under section 161. Plus that is at annexure 4 at page 36 minutes. Because input tax credit minutes which are supposed to allow not granted minutes. And I also simultaneously filed appeal minutes. That's appeal in the meantime disposed of. My humble submission is that your lordship will find because I have filed annexure 6 series appeal memorandum along with all documents, including invoice copies, STR, GSTR 2A, all reported downloaded documents, all documents. And how appeal authority dealt it, I could have opted for that 20%. But my humble submission here is now that I have filed everything and by a one-line order, if appellate authority, because 107, if your lordship will see, power of inquiry is there. The appellate authority cannot just decide on the face of it.
No, where is it one line?
No, my lordship kindly see the appeal order, Millers. Page 69, Millers. Page 69.
Begins at 9 and come to 17.
Your lordship will find these are all grounds noted at page 71.
72 is the
Yes, exactly correct, Millers. Your lordship will find para 10. That's the only Millers, so devoted for the purpose of deciding the case.
That's okay.
After thorough grounds of appeal, vis-a-vis assessment order, other documents I will record. It is found that contemptuous appellant
You are not avoiding paying 20%.
But if your lordship support this, certainly what your lordship direct, I will comply.
Right.
That's that.
That's right.
And
you pay 10%.
And now there is attachment. Your lordship will kindly permit me.
If you pay the 20%, the attachment.
Yes,
all right. Subject to the petitioner paying 20%.
To enable me to deposit, your lordship will kindly leave tax. Otherwise, I cannot utilize my money kept in the bank.
All right. It is pointed out that the petitioner's bank accounts. You have to give the account number, sir.
Account number is there, Millers, at annexure 3, page 32, Millers. Page 32, account yes, current bank account number.
All right. The petitioner's current account with HDFC Bank, Deepasahi Station Road, Baripada, stands attached. and therefore the petitioner is unable to pay the 20% tax amount to comply with the above interim order. This is after saying subject to. It is accordingly directed that for the above purpose, the attachment of the petitioner's account will stand lifted. And amount equivalent to 20% of the remaining tax will be allowed to be withdrawn by the petitioner for the purposes of making payment. So it is made clear that otherwise the account will continue to remain attached. Paragraph. Subject to such payment, no course of action will be taken against the petitioner during the pendency of the presentation. The IA is dismissed. 11th September. Notice the usual orders. I don't know if he knows the usual order. Does he know? Are you aware of the usual orders in these cases? Or
Liberty may be granted. I'll carry out the amendment in the application that I will file. So now what has happened? A circular has come to Government of India that the limitation will start after Millard's constitution of the bench and the
but it's silent on this course of action. That's what.
But one thing, my lords have already been following this practice of directing Millards that we are paying. Because now everybody is remediless. Because remediless in the sense, because after appeal order is passed, Millards, because normally 3 months for us and 6 months to the government to file appeal. Now, as per the circular, because of non-constitutional tribal matter held up in Madras, Honorable Madras High Court, now they say after President assumes office and notification that effect is made, 3 months from that date, Millards. After elapse of 3 months only, default will continue. So in view of this, Millards, issuing attachment, going for recovery.
I don't know why they're doing it. Yes. That should not play their hands.
Another notification, it is a good news for all the petitioners, Your Lordship. Another notification in the meantime has come from CBSE. In that notification for the period 17-18 and 18-19, Your Lordship, I'm examining that notification. Also, I have obtained instruction from the department. If that notification will be accepted, Your Lordship, all the cases will be disposed of and will be set aside to the assessing officer. Why, Your Lordship, in that notification circular, a modality has been fixed, Your Lordship, in that notification that the assessing officer, what happened in all these cases, since there is a difference, so it has been added. So in that circumstances, some chartered accountant certificate is required.
With regard to mismatch of ITC.
Exactly. And almost
supplier and recipient.
Almost in all these cases, that is the point, Your Lordship, in all the cases, because that is the only point till now decided by the.
I will be happy if Your Lordship.
I'm examining all the cases. So far the 17-18 and 18-19 major cases, all the cases will be disposed of at a stage, Your Lordship. I'm examining and I'll convey Your Lordship.
No, they have challenged the virus itself.
So far as the virus, they may
16 to
they may
see.
So they'll postpone it till they actually have a negative order. If they challenge the order, they can again challenge the virus.
The Lordship, that circular has passed on 27/12/2022.
Almost more than a month ago.
And Your Lordship, another High Court has passed that 1920 will be also applicable. Probably Your Lordship, even Karnataka High Court and another High Court has passed an order that 1920 will be also applicable. That circular will be applicable for 1920.
That is a different thing. But that has to be applied because the already CBSE has issued the notification.
But you will have to make a statement then.
Yes. For that reason, I have sent and for instruction.
You first get the list of those cases.
Your Lordship, I am preparing. I am also taking instruction and also I am preparing.
Only
and
exclusively, that is the demand.
Exactly. Your Lordship. Good.
All right.
Item number no coercive action, Millards. Yeah, that Your Lordship.
Yeah, I've already said.
My Lord, obligation. Item number 51.
May I please, Millards? This is an assessment which has been completed under section 144B of the Income Tax Act, Milord, without Milord giving me a draft assessment, Milords. Lordships have a similar matter on second
instruction because I'll take instruction.
Your Lordship would see, Milords, originally 140.
Nominal senior has somehow changed, Milord. I will reply that after Milord.
Your Lordship have said
that Rai has got enough orders, sir. I think at least in Mr. Rai's case.
This is Mr. Rai's case, which
Now
I was
the
fortunate.
minister
Ah,
has been-
that's
Lord, I'll reply that later on. Lord, I'll take notice. Lord, I will reply that.
Your lordship would appreciate, my lord, your lordships have also given handle to the department not to go and proceed afresh, my lord, in
That's
accordance
what-
with law. So let them,
Lordship, only Lordship give me protection, Lord. Or,
You protection.
Lord, I'll back.
your lordship may, your lordships have protected the interest of the department. I'm not going scot-free, my lords. I'm still within
No,
the
you want
nets.
time for instructions, you can take.
Yes, but I'll take instructions.
Oh, nice. We say notice, he accepts notice and seeks time for instructions till the
If you
next
Lord
day.
give
no
it that
course
he
of
will
steps.
appear and by the new provision, then Lord.
Then let this order pass.
Yes. New provision, Lord, I don't have any objection. I will not.
They can produce it in accordance with law.
My lords.
Yes.
All right. You say the challenge the present petition. Notice he accepts notice. The challenge the present petition is to a reassessment order dated 27th March 2022, passed by the National Faceless Assessment Center, Delhi. Bracket opposite party number 3. Under section 147, read with section 144, capital B of the Income Tax Act 1961, bracket Act. The short ground on which the challenge has been raised is that the impugned order was not preceded by a draft assessment order, which is required to be served on the SSC under section 144, capital B of the Act.
60.
Stop. The show cause notice preceding the reassessment order was not accompanied by such draft assessment order. Then reproduce para 4 here and 5. That's it. The petition is disposed of in their work terms. All right.
Your Lordship,
Annex 1
giving Lord liberty so that we depart.
No, it's there.
That-
That's para 5.
Lordship,
It's all Annex 1 and Annex 5 may be set
Yes.
aside now.
That's all there, sir.
No, Annex 1 and Annex 1A is there. It's Annex 1 and Annex 5.
5. All right. Instead of 1A, it will be 5. All right.
Obligement.
All right.
Item number 52. May it please, Mills.
Yes, please.
Plus the limited point involved, Mills, is certified copies of the order sheet and search warrants, Mills, are not being given.
What happened?
Yes,
Last
madam.
time you took time for instructions.
But I am filing counter today. Your Lordship, similar matters, Jagannath, his own matter is pending. My Lord, here the issue is not the proceeding has not yet been completed.
Correct. So why can't
And-
we give him copies then?
No,
Mills,
you're-
I have reached the second appeal stage proceedings, Mills. The investigation is not completed. I've reached the second appeal stage, Mills.
Good item.
Against the
Lords.
final orders.
Sorry.
Against the final orders.
Second, the assessment order has been passed, thereafter an appellate order, thereafter now the second, it is pending in second appeal.
If material are used.
Paragraph 11,
Those
Lord, the
material
stand
are
of the
used
revenue.
in the course
Sorry.
of assessment.
Sorry, Mills.
Those material which you are seeking.
No, but
certified
is
copy.
this officer who's sworn the affidavit aware that there been beyond the show cause notice already the matter is crossed?
Lord, I don't think, Lord, he is not aware.
He doesn't
because
file
he
para
has
reply,
not-
sir. The
he has
whole
not
problem-
stated- Yes, Lord, he has not stated it. So para only say that the so cause notice has been.
He should read the petition, sir. Unless a para-wise reply is filed, what's the point? Just
Today
give this
morning-
back. Let him file a proper. Just don't
Yes,
let's
Lord.
not take this.
Kindly back, Lord. Because today morning he has handed it over.
You say para-wise reply. With notice, he accepts notice. Then the short ground urged by Mr. Sashwat Acharya, learned counsel for the petitioner, is that the Deputy Director DGGI was not justified in refusing certified copies of the search warrant and order sheet / note sheets in the matter. Paragraph. Then you say para-wise reply to the petition be filed by the respondents within 4 weeks, rejoinder if any before the next date. Then you say no coercive steps will be taken. No further steps will be taken pursuant to the impugned show cause notice.
No, Mills,
There is no, yes,
in
before
fact,
the tribunal. No.
in fact, Mills, the facts is show cause notice was issued. And Mills, the law is that show cause notice can be issued only after the investigation is complete. Show cause notice was issued, assessment order passed. Thereafter, first appellate order has been passed. Now I have filed a second appeal during pendency of the writ petition.
But look at your interim application. Then that it's gone beyond that. You're still asking, saying not to proceed further to enable you to file a reply.
Yes, well, that is not what I'm pressing.
Then
That's only prayer.
Then no interim order. Just let him say.
Only prayer, Milord's 28th. The similar matter is coming, Milord's 28th.
Yeah. This is IA. You say this petition, this application is become infructuous and is disposed of. 28th September.
28th, Milord's February.
28th February. Then how can he file reply within 4 weeks?
No, I'll fine.
Okay. Reply be filed before the next date, you say. 28th, list on 28th February. All right.
Great. Item number 53.
May I please, Lordships? Lordships, in this matter, Lordships, limited prayer, Lordships, that the self-same official who has passed the order in original and I have complied the same depositing every tax, penalty and interest, the same officer has filed the appeal, Your Lordships. Page 31 and page 32, Your Lordships.
No, but why at this stage, what should we interfere? Whatever the appellate authority will pass that order.
Your Lordships, actually, I have already deposited the entire amount of whatever they have charged in order in original, Your Lordships.
All right.
And the self-same officer had filed the appeal and I have not challenged that order. I have deposited the tax amount. And how the self-same officer will file the challenge his own order, Your Lordships.
Anyway, that whichever appellate authority will deal with all that, madam. Why should we interfere at this stage? There's no need for us to interfere.
My learned brother may take instruction on that.
Why?
No copy has been served to us.
No, but why? Why should we get into this at this stage? Whichever is the appellate authority will deal with it.
But again, second
Just
round.
an appeal has been filed. No order has been passed on that.
But again, I have to appear before that authority for self-same cause for which I have already deposited the entire
Point out to
amount.
the authority, they'll deal with it. You say, since only an appeal has been filed and it's yet to be heard, it will be open to the petitioner to urge all the points being raised in the present petition before the appellate authority in accordance with law. The court does not consider it necessary to interfere at this stage. The writ petition is disposed of.
Obliged.
Lordship, my appearance may be noted. Item 54. My lord, GST second appeal issue. I have already made the payment of 20%.
You paid 20%. Or 10%?
10%? Balance 20%.
Same order. 11th September. All right.
Item number 55.
May I please, Your Lordship? Your Lordship, this is a matter wherein the petitioner is challenging the illegal rejection of the representation wherein we have seek for a refund of license fee of the veterinary outstill shop, which was forcibly and illegally closed down in violation of the Odisha Excise Act, my lords. My lords, what has happened in 20...
Again, you can go to the excise commissioner against the collector's order, right?
My lords, this is a fourth round of litigation. My lords, may kindly hear to my what I want to represent, my lords, that at 28/5/2019, ISC police station Aska illegally, without the permission of the excise authorities, closed down my shop only on the pretext that they wanted to investigation some of the in one of the murder cases. They want to investigate it. They raid our shop and closed down without the permission of excise authority. Thereafter, what has happened? We represented the collector. The collector thereafter inquired into the matter. There was a report under Annexure 2 which shows that Your Lordship may kindly see Annexure 2, my lords. Page 21, which says point number 1 and 3 that police has violated section 26 clause 3 of the Odisha Excise Act in closing down the shop illegally, my lords. Thereafter, another inquiry was also set up by the collector wherein it was allowed that that there was no law and order situation and it was the action of the police authorities was illegal, my lords. And they allowed to operate our shop after 9 months, my lords. There was a closure for 9 months. They allowed to operate our shop in 16/3/2020, my lords. Thereafter, what has happened? They sought for the area dues that during the closure period. We paid around 29,20,837 rupees, Your Lordship. What has happened? We had represented the collector to refund only. We have deposited the amount under protest, my lords. and subsequently we represented the collector that the amount is to be refunded as per the rule 151 of Odisha excise rules, my lords. My lords, may kindly have a glance. I will just place before your lordship a order of the last.
My lord, first of all, this is the collector's order. The writ was filed in 2020. For the first time, it is listed today, after more than 2 years. The collector's order, it has to be appealed before the commissioner.
Let him argue.
Yes, ma'am.
My lords, what has happened that there was a direction by this honorable court to consider my refund application for refund, my lords, which was rejected only on the flimsy ground that there was an apprehension that there might be a law and order situation and right situation, for which he rejected my representation for refund, my lords. I will also place before your lordship a judgment of this honorable court wherein a similar issue I have been squarely covered. Instead, I am in a better footing, your lordship. I'll just provide this case law, my lords. Relevant portion is para 4 and para 7, my lords. May kindly have a glance. Wherein it was directed to refund the amount that has been collected.
All this the commissioner can consider, sir.
Lords, this is the fourth round of litigation I'm before this honorable court.
Sometimes you go to the commissioner also. Every time you're coming to this court. Let's share the burden equally.
My lords.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the commissioner against the impugned order of the collector, rejecting the petitioner's application for refund. If such appeal is filed not later than 3rd April, accompanied by an application for quantitative delay, explain the delay on account of pendency of the present petition, considered in the course of law of the commissioner. The court clarifies it is not expressed in
Item number 56.
Madam, your lordship, item number 56 are rendered infructuous, my lords.
Infructuous disposed. All right.
Item number 57.
57 and 58 is not present.
Not pressed.
Item number 59. Sir.
My lords, on behalf of Mr. Ramesh Chandra Vera, I seek for an adjournment. He is ill, my lords.
All right. Counsel for the appellant is stated to be unwell. List on 11th September.
Grateful, my lords.
Item number 60.
My lord, on behalf of Mr. Mahanti, kindly pass over. He is on his leg.
All right.
Item 61.
In this case, there is a delay of 145 for 5 days for filing of this appeal, my lord.
COVID time.
In COVID time, nahi, before COVID. Yeah, the petitioner, applicant is a illiterate person, could not know the.
When he files a writ petition, it says stop being illiterate. After writ petition, no more illiteracy. You say,
let me notice the issue, my lord, to be just for.
Leave it open for some decision. You say the delay of 145 days has not been properly explained. The reasons supported are not convincing. Consequently, the court is not inclined to condone the delay. IA is dismissed. Accordingly, the writ appeal is dismissed. Nevertheless, the question of law sought to be raised is left open to consideration in some other appropriate case. All right.
62.
Same, 62, 63, same.
All right. 63 also. Right.
Stress admission, pastoral matter, item 11. Item number 11.
Despite a pass over, none of you is dismissed.
Item number 17.
May I please note?
Similar here, 31.
Page 16, Lord. The question of law frame, Lord. Two ground. One is, Lord, the bad debt was written off without any evidence as per section 36(1) BIA read with rule 36(2)(1) of the Act. That the assessor never produced any document. I have given page 11, the enactment of the 36(1) BIA read with 36(2) of the Act. No documentary evidence regarding existence of debt. Document evidence that the debt was taken into account income either in the previous year or earlier previous year. Documents show that a debt has been written off in the books of account. Documentary proof to show debt claim as a bad debt claim to bad debt under 36(1) BII of Institute Business. The tribunal, Lord, if I quoted, you will also see the tribunal finding, page 13, para 8 I have quoted. We have noted that the appellant gave advance of 2 crores to Mr. So-and-so for purchase of land. The assets in business real estate, the advance was given for the purpose of land, and the same has been duly reflected in the books of and so-and-so. The advance given as revenue in nature and it was stand particular due to some dispute. Land could not register the name of the assessor, seller did not turn up to refund the advance. Now, there is scrap of document, how is refunded, what is the defect, nothing. Mere statement of the assessing lot, the tribunal has come to finding that in view of the Supreme Court case, TREF limited 323 are considered. And another one is rule of consistency. As a first question, that the that in the books of account, something was earlier, the assessing officer has allowed the same, but later on, without any finding, the subsequent year, the IO was assessing officer reopened this issue. And the rule of consent tribunal is allowed, based on the Supreme Court judgment. My submission would be, in this case, in this issue, every assessment here is different, and rule of consent will not apply in each and every case, because all these books of account is different, and the issue has not been properly framed as earlier. That mistake cannot be continued to protect the interest of revenue. Therefore, we are relying on two judgment. We are
all these are same matters.
No. All are different.
Each is different.
Yes.
All right. So you say ITA 6, that is item 17.
Yes,
is a notice returnable. 11 September.
ITA number 6 it is not.
Yeah. That,
item 18.
That dispensing with you all. All right.
Yes.
Item 18.
18 Your Lordship, this is a
it's only sent back, no?
Yes, only sent back.
This being an order only of remand, the court does not consider any substantial personal flaw arise.
No, not only remand. Your Lordship seem not the question of law. The remand only that no natural justice and violate 2 times notification issued. Your Lordship see the order. Your Lordship.
All right, so one more hearing only has to be given. It's all right.
Your Lordship direct to appear before the tribunal.
Yeah.
He is not
fix a date.
No, tribunal is quashed. No, tribunal is quashed. Your Lordship see. Running page 26 now. Was the revisional proceeding frame 265 allow the grounds raised as in the interest of appeal before?
So let's read the reasoning. Now, para 14. Let's read the reasoning.
On the perusal above finding, the tribunal will find that in the absence of proper being provided a sense of revisional proceeding, the tribunal was the revisional proceeding under Scrutiny Act. In such case, we find the associate already proceeded through the Scrutiny under 43 Act so and has filed the complete detail called for the AO. Almost 21 point with interlay inputs, all detailed cash deposit, cash flow statement, detailed trade in receivable, detailed purchase, consumer transport charge, finance cost, etc. The assessors filed all these details before the ON called from time to time. Again, this very assessment year was selected for by the PCI.
Why can't it be sent back, sir? Because this kind of a ground saying you were not given time to produce materials shouldn't result in the whole thing being quashed.
Yes,
it should have been sent back. We'll fix a date and make time out.
Yes.
Lordships, in this present case, your Lordships, before the assessing officer, your Lordships, they are...
Correct. Yes. So what you're saying is, I wanted to produce those very materials for the CIT,
yes.
And I was not given a chance.
Yes,
that's all.
Yes.
You see, the present appeal with the revenue is directed against an order dated 21st December 2021 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack bracket IT80, allowing the SSC's appeal ITA number 17/CTK/2021, whereby the SSC had challenged an order dated 1st March 2021 passed by the Principal Commissioner of Income Tax -1 Bhubaneswar bracket PRCIT bracket, initiating proceedings under section 263 of the Income Tax Act 1961 bracket Act. Paragraph. You say admit the following question is framed for consideration. Was the IT80 justified in quashing the impugned order of the PRCIT on the grounds of violation of national justice without reviving the proceedings before the principal CIT for compliance with that requirement? Question mark. Paragraph. The perusal of the impugned order of the IT80 revealed that the ground that weighed with the IT80 to quash the order of the PRCIT was that sufficient opportunity had not been granted to the SSC to place details to support the original assessment order of the assessing officer bracket AO. Paragraph. It is seen that the IT80 did not consider it appropriate while setting aside the order of the principal CIT to revive the proceedings before the principal CIT to provide such opportunity to the SSC. Full stop. That should have been the appropriate course to follow, since all that the SSC was seeking at that stage was for further time to produce the relevant documents and materials. Paragraph. In that view of the matter, the impugned order of the IT80 is interfered with to the extent that while the order dated 1st March 2021 of the PRCIT under section 263 of the Act will remain set aside, the matter will revive before the principal CIT. That is the matter, that is the revisional proceedings, will under section 263 of the Act will revive before the principal CIT and will be listed there on 10th April 2023. Full stop. On that date, the respondent SSC will appear and produce all the relevant documents or materials that the SSC was seeking time for. And the principal CIT will then proceed in accordance with law and pass a fresh order within a period of 2 months thereafter. The court clarifies it has not expressed any view on the merits. Full stop. The appeal, the question of law is answered in the above terms. The appeal is disposed of.
Item number 19.
19, your lordship. Frame the question, your lordship, see the
same alternative view.
Yes.
3.
Question page 24.
Yes.
Whether on the fact the tribunal is like a right in law in quashing the imperial revision order by quoting that the principal CIT has taken a view in the matter and there is only an alternative view while there is no such view taken by the revisional authority. Your lordship, see the running page, the order of the 263 last page, page 49. May I please?
Yes.
The above submission from the SSC has been carefully examined. It observed that broadly the following claims are made to be considered relying on no number of decisions from the Honorable Supreme Court, High Court and Appellate Tribunal. The SSC has acquired a right in the property on execution of agreement for sale and payment of 90% of the agreed cost of the property to the promoter as advance. The right in property is a capital assess as per section 214 of the Act. The relinquishment of the right in the property and diminution of the right back to the promoter in lieu of payment made by the promoter also transfer as per section 247 of the ITA. Capital asset is transferred, thus it may be a capital gain oblique loss. No capital gain or loss claimed since cancellation of deed was not present in loss for registered till end of financial year 31/3/2013. The proceeding 263 right is not to be invoked since precondition of the initiation are not applicable in this case. It can be presumed that the AO's formed an opinion after complete inquiry and examination the assessment or does not reflect AO's opinion. Formation of opinion can only be established through expression of opinion. In view of the things, I am of the considered opinion the assessment here is erroneous insofar as prejudicial interest of
This is just repeating the statute. That's it.
Yes, Lord, yes, because Lordship has so many cases.
Careless, sir.
And Lord, what he has done, he has written back to the AO. And Lord, we are relying on true judgment that it can be written. Your Lordship know the section itself says it can be, if I'm place again the section 263.
So the reasons can't be just the repetition of the section, sir.
No, but he has carefully examined.
No.
And in the order itself, Lord, your Lordship see.
Yeah.
The before page, your Lordship see the AO was not giving any finding on that issues, not. And therefore, Lord, the.
No. This is an appeal by the revenue against an imputed order dated 23/12/2021 of the IT-80 conduct bench, allowing the SSC's appeal ITA number 178/CTK/2018, which is directed against an order dated 29 March 2018, passed by the principal CIT-1 under section 263 of the Income Tax Act 1961 Bracket Act for the assessment year 2013-14. Paragraph. Having heard learned counsel for the department and having perused the aforementioned order of the principal CIT as well as the order of the IT-80, the court is of the view that the IT-80 did not commit any error in setting aside the order of the principal CIT, which, as the court views it, simply repeated the language of section 263 of the IT Act regarding the original assessment order being erroneous and prejudicial to the interests of the revenue without actually giving the reasons for such conclusion. Full stop. Consequently, no substantial question of law arises for consideration. The appeal is dismissed.
Item 20.
20, your Lordship, here is a case, my Lord, if Annex 20, your Lordship, see, it is totally a re-hearing of the matter. New fact, new law has been considered while passing the Lord order under section 254(2). Your Lordship, see, my Lord, whether word 47 is applicable, there is no clerical mistake, not happened in the face of record. Here, we are clearly re-hearing the matter, your Lordship, see the order itself. And start from Indian Press 3023.
Only recall, sir. They hearing it all afresh. It's only a recall.
No, it is not 252 or petition has been considered by tribunal after passing the order of the original order of the tribunal.
They will again hear it, sir.
No.
They're only recalling the earlier order dated 18/1/2021 so as to adjudicate all the issues afresh.
Yes, Lord, that cannot be, Lord. If you Lordship see the language of 254.
Yes.
Lord, it can you only in the apparent face mistake on the apparent face of record, your Lordship.
Correct.
And here, Lord,
all these issues are interfering.
It's all right.
And we say the impugned order allows an application under section 254(2) of the Income Tax Act 1961, recalling the earlier order dated 18 January 2021 of the IT-80 and directing fresh hearing of ITA number 366/CTK/2019 filed by the SSC for assessment year 2007-8. Paragraph. Having heard the receiving standing counsel for the department and having perused the impugned order of the IT-80, the court does not find any substantial question of law arising from the impugned order, which requires to be determined by this court. Full stop. The IT-80 has given sufficient reasons why it thought necessary to recall its earlier order. Full stop. Since in any event the appeal is going to be heard afresh, the court does not consider it necessary to interfere. The appeal is accordingly dismissed.
21.
21 19 was delay.
91 days.
19.
Ah,
Not the
delay control.
the question is not the is all the all these similar all these matters from start from 2831 all are same group of assessing here the claim of exemption under section 1038 after sale person tax is paid by the person to disclose before the survey team when the claim is made in a revised statement before the year without filing the valid revised return. Whether traveler justified to allow the exemption under section 1038. Your Lordship, may I place 1038 first note, then I'll go to the 38 million.
Any income.
Any income raising from a transfer of a long-term capital asset.
1.157.
1.151.
Here it's 157.
Any income raising from transfer of a long-term capital asset being a equitable share in a company or a unit of an equity-oriented funds. The transfer of subclause A, transfer of sale of such equity share or unit in enter into an date on which Chapter 3I Finance Act 2 come into force and such transaction chargeable to security transaction tax under the chapter, provided that the income by way of long-term capital gain of a company shall taken into account company books profit and income payable under section 115J. Provided also that nothing contained subclause 1 shall be applied to a transaction undertaken as recognized stock exchange located in international financial service center and where the consider of such transactions is paid or payable in a foreign currency. Provided also that nothing contains clause shall apply to any income raising from the transfer of long-term capital asset being an equity share in a company if the transaction of acquisition other than the acquisition notified by the central government in his behalf such equity share is entered into after 1st day after 24 October 2004 and such transaction is not chargeable to security transaction at under so. Provided nothing contained in the clause shall apply to any income charging from transfer of long-term capital asset being an equity share in a company or a unit and equity-oriented fund or unit business trust made on or after 1st April. Purpose of this clause, equity fund, so and so, so on. Here, my lord, the your lordship see the order of the tribunal.
Concurrent findings, sir. They've agreed with the CITA.
Yes, Lord, that concurrent finding, but Lord, the if your lordship see the I have relying on two judgment of this honorable court, Lord. I have quoted that running page 10, the judgment of the honorable Supreme Court, Lord, para 7. Here, Lord, the tribunal finding is that the person who has purchased no cross-examination has been allowed to them. Lord, in the assessment proceeding also, he has not claimed for any cross-examination. And this court said, Lord, in the High Court said that the order has been grounded no opposition cross-examination is there. Lord, he has not asked for even, Lord.
It doesn't have to, sir.
And
it's adverse to him, it has to be provided.
And Lord, the question, Lord, the section 38 in this issue, Lord, has never been considered in any other case.
Factual, sir. It's factual. You see, these appeals by the revenue arise from an order dated 21st, common order dated 21st December 2021, passed by the ITAT, Cuttack Bench, Cuttack. In
it is amount to a penny stock transaction, Lord, I can say. If your lordship, this transaction is totally not transaction. One time he has accepted and paid the tax, and subsequently is non-filing a revenue file a statement that claiming the execution. Once he has accepted in the search proceeding, he has paid the tax and admitted no exemptions claim. Thereafter, they filing a reverse statement, he claimed that the exemption. That is what will stand as the revenue. Can it shifted one and another in each and every stage?
All right. Dismissing the revenues appeals, ITA number 42 to 50, public CTK 2020, against the corresponding orders of the Commissioner of Income Tax Appeals, bracket CITA, for the assessment years 2014-15 and 15-16. Paragraph. The questions ought to be urged by the Revenue Department in these appeals. Was whether after participating in the, after making certain statements in the survey, the SSC could, and not claiming exemption under section 10(38) of the Income Tax Act 1961 at the stage of the assessment proceedings, could the SSC turn around and claim such, and make such claim of wanting to cross-examine persons making adverse statements against SSC at the stage of the appeal before the ITAT? Question mark. Paragraph. The impugned order of the ITAT has sufficiently dealt with the factual details concerning the respondent SSCs. Full stop. The question was regarding the claim of long-term capital gains on shares in terms of section 10(38) of the Act. Full stop. Or during the course of scrutiny assessment, a revised computation was filed by the SSC claiming the above exemption. Full stop. After the AO rejected the plea, the SSC went before the CIT bracket A. Full stop. The CIT A was satisfied that the purchase of equity shares had been made through account payee checks, and the shares themselves were held in demat account for more than 12 months and then sold through the recognized stock exchange after payment of security transaction act tax. Stop. A reference is made to the CBDT circular, which debarred the revenue from obtaining admissions oblique statements during the course of survey. Full stop. The SSC, the ITAT also noted the settled position in law that if an SSC had wrongly offered an item of income or omitted to make a claim of deduction in the return, he was entitled to correct such a mistake by making a request to the AO to that effect. Stop. Another ground on which the ITAT found fault with the additions made by the AO were that reliance was placed on statement of single quote so-called entry operators unquote to justify the additions under sections 68 and 69 of the Act. Full stop. These statements were recorded on various dates in some other proceedings not connected with the SSC. Full stop. Therefore, these and further, the statements were recorded much before the date of survey conducted on the SSC. Full stop. It was unable to be disputed by the department that the SSC did not have an opportunity to challenge the such statements, and further, no opportunity to cross-examine the so-called entry providers. Full stop. Paragraph. Having heard learned counsel for the department and having perused the impugned orders of the AO, the CIT bracket A and the ITAT, the court finds that both the grounds, namely the claim for the benefit of section 10 bracket 38 of the Act and denial of an opportunity to cross-examine the entry providers, come up purely turned on facts. Full stop. The ITAT was justified in accepting the plea of the SSC, since the failure to adhere to the principles of natural justice went to the root of the matter. Full stop. Also, the CBDT circular that permitted the SSC to file revised returns if it forgot to make a claim was also not noticed by the AO. Full stop. In the considered view of the court, the ITAT committed no error in concurring with the view of the CITA in dismissing the revenues appeals. Stop. No substantial question of law arises from the impugned order of the ITAT that calls for interference by this court. The appeals are accordingly dismissed.
Up to 31 same, my lord.
Up to 21 same.
But my lord, some cases 19 days or some cases 20 days delay.
Everywhere delay condoned. All right.
Please.
All right. Up to 31.
Item 37, I am getting the photographs. Will also take up the matter after launch, my lord.
All right.
But I have got some photographs. I am getting it printed, my lord.
You show it to him, sir. Mainly showing it to him only. You got it on my phone.
I am also trying to contact the sub-collector.
All right. 2 o'clock. 2 o'clock.
What IIC told me over telephone that this is a separate compound near the school ground. But traditionally the Mela is going on there. Particular place. And school functioning is not at all affected. That they are ensuring. That your lordship can observe in the order if your
as long as they give that assurance, that's okay, sir.
School functioning will not be affected at all. That the district administration will ensure.
Yeah, that is inevitable.
That was also the earlier observation by this honorable in the previous writ application.
Yes.
If it is organized in the school premises, it be shifted to any other place.
No. If your lordship may kindly imagine, 5 days already expired and another 5 days. Your lordship can direct if your lordship
it is
that
still
the district
16.
administration should ensure that this normal functioning will not be.
This open space is not like Revansha Collegiate School. You mean to say that?
No.
No, Revansha Collegiate School has.
No, this is also a big school. What I
that is same compound.
Yes, same compound.
Compound is same. Your lordship can imagine. Compound is one, but the playground is always outskirt of the school. School and playground that can be divided.
Divided.
And in small places, getting a big ground for Mela is also very.
There are big patches of land. There are big patches of land where
you should have come prior to the commencement of Mela, not at this stage. After 5 days is completed for another 5 days. If how we will stop the Mela, it is against the public sentiment.
There is no question of 5 days, completion of 5 days. They started it from 7th. Saraswati Mela was started from 7th. On the guise of
Dumusa. Your lordship, imagine at the meets, how we will stop the Mela. And the slot, you are only one. The petitioner is only one. And the entire people of Udala, at least 10,000 population, they are enjoying the Mela.
But concerning this subject also, there was agitation by the local public before the collector.
Where is that material? Where is that material?
The representation is there.
Representation will be considered.
The person is not one.
In any case, if your lordship will direct the normal functioning of the school will not be hampered.
All right. The apprehension expressed in the present petition is that permission is being granted by the local administration at Udla in Mayurban district for holding of single ports Dumusa fair, unquote, in a school premises, which might adversely affect the interests of the students preparing for the annual exams. Paragraph. On instructions, Mr. D.K. Manti, learned AGA, informs the court that the Mela is not being held in the school playground, public premises.
Not being held. It
It's
is
not.
being-
It's
It
not
is being held in
school-
the playground.
school premises.
Playground, in the
Yes.
playground,
Okay,
and
being
which
held
is
in the
not
school
affecting
premises,
the
but-
normal
yeah,
functioning of
but-
the school.
But in the playground, which is adjacent to the school
Yes,
and is no way affecting the
normal functioning.
normal, functioning of the school or adversely affecting the students. Paragraph, the court would like to emphasize that the local administration should ensure that the holding of the mela does not hamper the actual conducting of classes in the school or disturbing the students in any manner whatsoever.
That is fair enough. Your Lordship. Your Lordship may direct that this order be communicated to the sub-collector Kaptipada.
All right. You say this order be communicated to the sub-collector?
Sub-collector Kaptipada.
Kaptipada. District Mayurbhanj forthwith for implementation.
Your
Petition
Lordship,
is disposed.
yes, yes. Lordship, observe only after, if there is any mela, that will be after school hour.
No, that is
So,
schedule
leave
is-
it at that.
So how it is affecting?
No, this
If
is
my
not-
lord,
this
if
is
my lord
only
senior
going
is submitting
beyond
that
his-
it's not,
It is
not
highly
going here.
unreasonable.
Not-
That is Mela schedule
No,
is
why unreasonable? This is the unreasonable on
the
the part
only
of the
one
administration.
person is claiming that all these.
This is the unreasonableness on the part of the administration. Well, in spite of the previous order of the Supreme Court, they are insisting to organize the mela in the school premises.
All right.
What my lord senior is submitting is a politically motivated. This is only politically motivated.
All right. No, all the more why we should stay out
Then
of
you
it.
are also a politically motivated petitioner.
Maybe.
Then you
Then
say
all the more
that
why the court should actually stay out of it. Yes.
those PIL should not be entertained at your
Yes.
instance.
Item 40.
Obliged.
Yes, Lordship. I am for the petitioner. Lordship, there is a provision for revision under section 253 of IT Act.
That is the appeal man.
Yes, sir.
Appellable order against the revision appeal lies to the.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a statutory appeal as provided under the Income Tax Act against the impugned order. Of the principal CIT.
Yes.
Under section 263 of the Act. Stop. If such appeal is filed not later than 3rd April, accompanied by an application for delay, explaining the delay on account of the pendency of the present petition, will be considered in accordance with law by the ITAT. The court clarifies it is not expressed anywhere in the matter.
Yes.
I am
The
appealing
writ
for
petition is disposed of, is withdrawn with liberty is prayed for in the above terms. All right.
Item number 60.
It may please your lordship.
Anchileka High School.
60. My lord, the appellant has challenged the order of Honorable Single Judge under Annexure 2, my lord.
No, it's 4 and 5 are served now. Respondents 4 and 5. have been
5, my
served.
lord, respondent 5 with the
Haladar Sahu.
Aldar Sahu with the petition, read petitioner.
But I have appeared already.
4 is the
appeared
headmaster, my lord. That 4 is not necessary pro forma party. Because the headmaster cum secretary has filed this writ appeal.
I see.
The limited question is, your lordship set up. in
Let me complete
order
my
dated
submission.
26
Let me
10
complete my
2022.
my lord, let me complete my submission. What is the illegality has been committed? Well, the opposite partner 5 was appointed as fourth peon in the Chodika High School, Kegaon, which is an aided educational institution, my lord.
My lord, I am for the state copy not solved as per your direction. Opposite partner 1 to respondent 1 to 3.
Copy has been solved on here.
My lord, kindly see the order dated 26.
My lord, solved on 2/11/2022, my lord. 3 extra copy has been solved on that.
No copy.
No copy. 2/11/2022, I have solved.
All right. One more copy be served. Appeal memo on counsel appearing for opposite parties 1 to 3.
1 to 3.
Within a week. List on 9th August.
May I pray one thing more, my lord? Your lordship issuing notice as to whether who will pay 75% of the area. But despite the order in 2018, I should be reinstated. Till that I have not been reinstated. That order has not been interfered with. Your lordship, the notice limited to the question who shall pay 75% of the back wages of the
You
respective
say,
number five.
since the notice was issued in the present appeal on a limited question, the respondent number 5, if not already reinstated, should be reinstated in the meanwhile.
My lord, one thing, it is, my lord, contrary to the judgment of the Honorable Supreme Court, reported in 2003-10 SEC 411.
That's all right, sir. We issued notice only a limited question. All right.
For admission item 60. That direction should be given to the district education officer, my lord.
We're not,
He is
just said
he is the authority. I am not the authority now.
Whatever. All right.
Item number 64.
64, my lord, to 60 days delay, my lord.
260.
Yes.
The delay is not condoned. Accordingly, STREV is dismissed. The question of law is left open for decision in some appropriate case.
Item 65.
The present petitioners are the allotee of the shop rooms to the Bhubaneswar bus stand, my lord, by the Orissa State Road Transport Corporation, my lord. In this, the notice was issued to them to pay the service tax, my lord. As per the adjustment of the service tax limit is 10 lakhs, my lord. What the petitioner is only shop owners was paying the rents only, and the service provided the business.
We demand notice, sir. You have to seek other appropriate remedies. Service tax demand, you have other remedies. Leaving it open to the petitioner to avail of the other appropriate remedies against the impugned demand of service tax. The petition is disposed of, the interim order is vacated.
Oh, right. And I am appearing for the OP.
All right.
I am giving.
All right. Yes, yes, same order.
Item 66.
Lord, may I please, Lordship? Lord, this is covered by your Lordship's judgment in Kalyani maternity.
SLP has been dismissed, my lord. That is the order, my lord. So your Lordship's order remains valid, my lord.
So that's correct.
This petition can be disposed of.
Lord, Kalyani maternity, that is WPC number 6590 of 2012. It's judgment by your Lordship and Justice Rao.
That's been upheld.
That has been upheld by the Honorable Appeals Court. That reference gives WP.
I have given copy.
So now what happens?
Lord, it is to be quashed. The impugned order is to be quashed, the Sanishchar one.
All right. The court has been shown a copy of the order dated 7 November. Make a note, tell make a note in our compilation. 7th November 2022, passed by the Supreme Court of India in SLP Civil 19268 of 2022, dismissing the SLP filed by the Bhubaneswar Municipal Corporation against the judgment of this court dated 22nd April 2021 in writ petition civil 6590 of 2012 bracket Kalyani Maternity Hospital Private Limited versus Municipal BMC, whereby this court had quashed
the determination of holding tax as per the new one.
Levy of holding tax, levy and collection of holding tax, single quotes holding tax, unquote. Full stop. In that view of the matter, the impugned order dated 1st October 2019, rejecting the representation made by the present petitioners, is hereby set aside. It is clarified that consistent with the judgment of this court in Kalyani Maternity Hospital Private Limited Supra, no holding tax can be levied or collected from the petitioner. Except in accordance with law. Correct. The petition is disposed of.
This is to be quashed this one time.
Sorry?
1st October, Annexure 1.
We've set it aside. I think Annexure 1 has been set aside.
Milord, I pray for a small accommodation. This item 80 hearing, because today is the death anniversary of my father-in-law.
Okay.
In father, I can take an excuse.
No, item 80?
80 some other day. Any day, Milord, that is also the same Bhubaneswar Corporation matter. And that was linked along with this. So that is with regard to user fee. Maybe
Mr. Manas Mahapatra has very strong views on that.
I think Lordship, in fact, directed the petitioner to file an affidavit, additional affidavit filed by the state the last date. So that rejoinder not been filed by the petitioner.
So we'll just, he needs an accommodation. All right. You said item 80, Mr. Pitambar Acharya and Senior Counsel for the petitioner is in some personal difficulty today. So list on 9th August is a very good date, sir.
Why not?
That's the let's find. Yeah, interim order to continue.
We hope a lot of things before that. Before that. we want to see you in continuation in some other forum.
But we'll celebrate on 15th August.
All right.
Let declare blessed.
Item number 67.
Council for the state. Item 67, this pertains to that damaged road. Because on the last occasion, I had shown some photographs of the instruction. So we were supposed to complete it by January 2023.
What happened?
However, the same has not been completed yet. I've got photographs today also and instruction. So,
you've seen it?
Not.
See, you should go there yourself. How will you counter this? Or ask someone to show you live. Now technology is there, sir. All villagers, everybody's got mobile phone now.
Well, it's by the end of this month we intend to complete it, because there were two
now
issues.
It is stated. Okay, now Mr. Ishwar Mohanty states on instructions that the work of constructing
the road from SH10A to
dry lean concrete road with pavement will be completed by the end of February 2023. List on. You keep it towards the end of March so that you're not again embarrassed.
Yes,
29th March.
Item number 68.
I may be pardoned, submit me, Lord. My prayer before my lordship to construction of foot-over bridge in Chhatrapur main station, my lord. It is incomplete, my lord. Thereafter, they didn't come, my lord.
There is railway, your railways.
Now, what happened, my lord? They highly reply, my lord. Something is wonderful. Regarding construction of a foot-over bridge, nothing is there, my lord.
Which is a good thing, sir, which means they might build it also.
No, my lord, they are saying it is not a maintainable.
Oh.
That is a word is used generally.
Bridge is not maintainable or your petition not maintainable?
My simple prayer before my lordship, it is the station was in 1899. Railway station of Chhatrapur. And there number of people are suffering. They should construct the foot-over bridge. That is my sole prayer before my lordship. They are not doing so. They are saying that it is not maintainable.
My lord, I have mentioned in para number 6, my lord, the averment made in paragraph 5, the writ petition disputed and denied the opposite party in reply submitted that proposal for extension of foot bridge already sent to railway board, my lord.
That's not enough, sir. When was proposal sent? Now you're also railway board.
Yes.
When was proposal sent? What happened to the proposal? How many people should die for you to get the proposal approved?
I have just my whole prayer before my lordship. Number of people are suffering, my lord. The station was in 1899 British. There was the main station of railway station, my lord, in Chhatrapur. Everybody knows it. But they are not, they are illiterate people. They are suffering like anything. They are not
illiterate. They are not, sir. But
suffering. There are number of people killed. Number of cattle damaged.
Yes, yes.
My lord,
when was it sent? When was it?
Pending, my lord, already.
Sorry?
My lord, already pending proposal for extension.
Since when, sir?
My lord, for proposal 2024 and 23 and 24 proposal. Page number
When
3.
was it sent?
Page number 3, my lord.
No. When was it sent, sir? You have to give details. The
But-
affidavit is there.
Yes, ma'am, that is not mentioned there, my lord.
The preliminary counter affidavit filed by the Railways, East Coast Railway, is bereft of the particulars as to when the proposal to extend the foot overbridge in Chhatarpur station towards platform numbers 4 and 5 was sent to the railway board. Stop that. A further affidavit shall be filed explaining the precise date on which the proposal was sent and what has happened to the proposal after it was sent. Stop. A separate notice be issued to the there must be some member. Which member of the railway board will be?
My lord,
In the railway board, which member is in charge of all this? Proposals. There must be
my
some
lord,
member.
affidavit filed by divisional engineer South, my lord.
No. If it is pending the railway board, they'll all simply say it is pending the railway board. To the secretary.
Secretary was the party. My lord, I made a party also read petition to exhausted all opposite party. But they are saying a new thing, that something is pending.
No, railway board is the ultimate authority, sir. So all these parties will simply tell you it's pending the railway board. Then to be railway board which was secretary. Something called secretary railway board. Just see the website of the railway board. No, just go up. Railway board. Oh, no, further, come down. Infrastructure. Just move this. No, here. All right. Separate notice will issue to the principal executive director infrastructure of the railway board to inform the court on affidavit what has happened to the proposal sent in this regard and how soon will steps be taken to implement the proposal. The registry will ensure that the present order along with a copy of the petition will be emailed to the principal executive director infrastructure railway board for compliance. List on. But this was just for information.
My lord.
What we did is went on the website, found out which person is dealing with these issues. This is for your future reference. When you file petitions like this, you should know how the railways work. List on 29th March.
Item number 69. Wait, please, Your Lordship. My Lord may see my Lord's last order dated 22/12/2022.
Where's Mr. Padi is there? Or?
My Lord, two things have been done, my Lord. My Lord, here I had drawn my Lord's kind attention.
No, where is Mr. Padi?
I am on behalf of Mr.
You are appearing in
My
the
My Lord, in paragraph 2 of the order, my Lord, my Lord was pleased to refer my submission and with regards to payment of 6 lakhs. And Mr. Mahanti was instructed, directed to verify.
So, the state does not have a separate special policy with regard to this particular disease. But what we have said is that, my lords may see what we have said is that under the BSKY scheme, these patients can avail, because the upper limit is 5 lakh, that is the upper limit. So they can avail cashless treatment up to 5 lakhs in the empaneled hospitals under the BSKY.
Good enough, sir.
My Lord. And other things, my Lord, on being directed by the AIIMS Bhubaneswar, my Lord, one of the petitioner, my Lord, who has been mentioned in A, my Lord, Mr. Das had been to Center of Excellence, Calcutta, with the list of the patients, my Lord. So authorities directed that we will send the intimation to you for attendance. But though, my Lord, he had attended on 21/12, but till date, no intimation has been received by them, any of the patient, father of any of the patients, about attending the Center of Excellence, Calcutta.
It should not be one empty format.
We'll find out, Your Lordship. We'll find out, Lordship. On this matter after 7 days.
Each day is important for this type of patients.
Correct. Mr. D.P. Dalal, senior counsel appearing with the petitioners, points out that pursuant to the order passed by this court on 22/12. When did they go, sir?
They had gone on 20. They had gone on 21/12. One day prior to 1 day prior to passing of this order.
No,
he was called by the AIIMS, Director AIIMS, and
AIIMS where? Calcutta?
No, AIIMS Bhubaneswar. On being directed by him to go to Calcutta Center of Excellence, and he had met the authorities there.
No, when?
On 23rd December, my Lord.
All right. It is stated that the that as offered by the Government of India in its affidavit dated 9 November 2022. Whom did you say, sir, went with that list?
Ballot?
No, you said a person went with the list.
Sangramjit Das, who is the father of Ballot Satyamanu Das. Well, let me see my writ application, page 7. A, patient number 1. A, Satyamanu Das, his father Sangramjit Das had gone with all the papers.
All right, Mr. Sangramjit Das.
Sangramjit Das, Ballot.
Sangramjit Das, father of Satyamanu Das,
Ballot,
had approached the Center of Excellence in Calcutta
with all the papers of all the patients,
the entire list of patients who would require treatment, and was informed that they will be sent separate intimations of the dates on which they should receive treatment. Stop. He states that till date, no such intimation has been received by any of them. Full stop. Counsel appearing for AIIMS Bhubaneswar states that he will seek instructions forthwith. And after getting in touch with the Center of Excellence in Calcutta, ensure that intimations will be received by each of the patients whose names have been furnished to the said institution about the dates on which they should come to the Center of Excellence at Calcutta to receive treatment. Full stop. On the next date, the court will be informed of compliance with this direction. Paragraph. As regards the benefits extended to children suffering from Duchenne muscular dystrophy, bracket DMD in Orissa. Mr. Ishwar Mantil, an additional standing counsel, has placed before the court written instructions dated 30th January 2023 received from the Joint Secretary to the Government Health and Family Welfare Department, stating that beneficiaries of the Biju Swasthi Kalyan Yojana, bracket BSBY, are eligible for cashless treatment coverage of rupees 5 lakh per annum per family and an additional rupees 5 lakh for women members. Full stop. It is stated that a patient of DMD can avail the cashless treatment under BSKY empaneled hospitals under single quotes unspecified package up to an amount of available balance in the wallet. Full stop, unquote. This statement is placed on record. See list on.
May I just, with your lordship's permission, they are saying that in the empaneled hospital, and now we have been referred to AIMS Calcutta, which is not an empaneled hospital. That your lordship may consider. I have nothing more to
Center
add.
of Excellence.
Yes, ma'am. Center of Excellence at Calcutta. So the government of Odisha is showing the list of empaneled hospital at Odisha for the eligibility under the BSK.
Empanels there.
Outside also.
Hospitals outside.
This is outside.
Because I'll have to check if this is not there, I'll just take instructions.
All right.
And ask
Mr. Mahanti adds that he will seek instructions on whether the centers of excellence outside of Odisha would also qualify to be considered as list of empaneled BSKY hospitals. All right.
If not, it's there, then it may be. Otherwise, we will not get it.
Considering the peculiar problem faced by the person suffering from TMD, the government will issue a further clarification in this regard. All right. Government of Odisha will issue. Full stop. List on
15th March.
Sorry?
March ballot, in the month of March.
Yes.
Because of my only ballot, we are getting this.
2nd March.
Ballot.
And the last item, that is 35002. In that case, I am appearing, but my name is not appearing for the Union of India.
Yes, all right. We put down his name.
That order may be applicable to 35002.
It is applicable to all this.
All right.
Item number 70.
70, my lord, I need some more time for instructions, my lord. On 31st/10/22, we have taken time for instructions, my lord. No instructions has been come, my lord.
At the request of counsel to the department who needs more time for instructions, list on. August 16th. Interim order to continue.
Item number 71.
Similar
I-
matter has been
I may be-
posted for September 2022.
On behalf of Mr. S.K. Dalai, the matter may kindly be similar, two similar matters have been posted to for September, my lord,
Correct.
by this honorable court.
Yeah, list on 4th September. All right.
Interim order to continue, my lord.
Interim order to continue.
Item 72.
Obliged, my lord.
72, we have already filed the counter, my lord.
That's, as a last chance, I pray for 2 weeks' time to file rejoinder.
All right. Rejoinder to be filed for the next date.
Interim order to continue.
Interim order to continue. 16th August. All right.
Item 73.
16th August. Manners. Yes, just after independence.
May I please? Yes, please. 73, my lord, time to file counter. First appeal GST matter, my lord.
Okay. For the 8 weeks time is granted to file counter. Rejoinder for the next date. Interim order to continue. Same, 16th August.
Item 74.
In item 74, your lordship, in compliance to the direction of the SBI LDR 3 by the designated committee, I have made 4 attempts, your lordship, for repayment, your lordship. On the 4 occasions, your lordship, although money has been debited by lords, on the same date it has been credited to my account. My lord, in the similar circumstances, my lord, in the case of Happy Travels, your lordships, following the order of my lords in the case of Nagam Hospitality, directed to the opposite party to issue the masters manually, your lordships. And the opposite party has, following the direction of the my lords, have already issued the manual, the SBL there for your lordship.
What does it say in the counter?
My lord?
In the counter, what does it say?
Para 4, my lord. 30 days time is given to make the deposit, my lord. And
No,
that's
but
last
technical
date.
error, he says, sir.
Yes, last date was extended thereafter. Even after the extended period, my lord, he has failed to deposit.
Fail meaning he says whenever he tries to do it, it's not accepting.
This is a mechanical process, my lord, entirely electronical. He has to do it, my lord. It's his duty to make payment.
How is he supposed to do, sir? If everything is electronic, online payment,
yes, my lord.
How is he supposed to do it if it doesn't accept?
My lord, page 4 of the document submitted today, my lord, is
I think
directed.
the same Happy Travels order will pass, sir.
Yes, my lords.
You say the court has perused the counter affidavit filed by the opposite parties. Full stop. Apart from merely stating that the petitioner has not made the payment within the extended time, the counter affidavit does not acknowledge the technical difficulties faced by the petitioner in making such payment as has been explained in the petition. Full stop. If the system is unable to permit the petitioner to make such payment, as a method will have to be worked out by the department to deal with such contingencies by permitting manual processing of the manual processing. Full stop.
There's a circular, page, para 19.
Your reply has only 12 paras of the judgment. Right. In similar circumstances, this court referred to the instructions dated 17th March is in its order in Nagan Hospitality Services Private Limited. There's a Central Board of Indirect Taxes and Customs 2021 50 GSTL 518 Orissa. Had noted the instructions dated 17 March 2021 issued by the Department of Revenue permitting such manual processing of the declaration filed under the SVLDRS rules 2019. Paragraph, the present petition is according to disposed of. With the direction to The designated committee,
My lord.
SV LDR scheme, bracket opposite party number 5. To accept the payment of rupees 30,25,811.40 as per SV LDR-3 dated 25th January 2020. And to issue the SV LDRS-4 in favor of the petitioner. By either accepting manually or by opening the web portal to permit online filing specific to the petitioner. This direction be complied with within 4 weeks. The petition is disposed of.
My lord, phrase SPLDR may be issued, my lord.
Sorry?
Phrase SPLDR kindly be issued, my lord.
I think
Phrase
said that.
SPL 3, my lord.
And to issue SVLDR-4, we've said that. Right.
Grateful, my lord.
Item number 75.
25, 76, my lord, more time to file counter, my lord. Fast appeal GST matter.
Reply we file within 8 weeks. Rejoined appendix. Interim order to continue. 11 September.
Grateful, my lord.
76.
Same.
Same, my lord.
All right.
The interim order to continue.
Have said.
Item 77.
My lord, 75 interim order to continue.
Yes, I've said that, sir.
Obliged. Item number 77.
Lord, there are developments taken place in the meantime. Lordship would see annexure 1, page 9. That is subject matter of challenge here by the excise deputy commissioner. Lord, the shop in question, in fact, stood closed from 9th of May 2015 because of the huge public objection. That report is available. That your lordship will find it at page, my lord, at page 13. The excise authorities report 9/5/2015 shop remained closed due to serious public objection and they did not allow to open the shop. Page 13, man.
Yes.
Now, pursuant to this, the excise authorities passed an order to me that I am to shift the shop to a non-objectionable site, annexure 6, page 14, man.
Yes.
Now, thereafter, I applied for shifting, which is apparently 35 kilometers away. That's their own report is, my lord. Page 16. 35 kilometers away from the existing site.
Yes.
Is that clear, man? Now, your lordship, see, after I pursuant to this report, they did not allow me to shift the shop on the ground of this distance. I approached this honorable court. Now, this honorable court passed an order setting aside the order directing to reconsider, referring to Khamardi Samal's case, that distance cannot be a factor, directed to reconsider me. Now they reconsider it and directed me, kindly see annexure 1 now. Directed me to submit an undertaking, written undertaking from the licensee to pay consideration money till the year 1920. Means my shop is closed since 15. I'll submit an undertaking to pay the consideration money for 5 years. Then I'll shift the shop. Then next paragraph, your lordship may see, the commissioner is considerate to get a report from the collector to reduce the MGQ, para 5. Now, my lord, the development is in the last lottery, I have even lost my license. It is no more available to be shifted. So only question is the MGQ and license fee for during this period, I do not have admittedly license. So it is to be waived. Either I'll approach the commissioner or the collector or the government to whomsoever my learned friend Mr. Manti agrees.
No. The till date you have not been served with any demand notice. Now the shifting matter is under challenge in this writ petition. That has become infructuous. If at all any demand notice will be issued to you, then it is open for you to challenge it in due forum.
Okay. You see, due to passage of time and subsequent developments, counsel for the petitioner states that the petitioner no longer has a license to operate any shop, and therefore the question of shifting of the shop does not arise anymore. Stop. As regards the waiver of the MGQ for the period during which the shop was closed, Mr. Mahdi states, as and when any demand is raised on the petitioner, the petitioner can always seek appropriate remedies in accordance with law. So placing on record the above statement, the petition is dismissed.
Yes, MGQ and consideration money, both.
Oh, yeah, MGQ and consideration money.
Right, great.
All right.
78.
May I please? It is so, madam. And the appellant in this case, madam, all the basis case, madam. It is filed by the Odisha State Transport Corporation, madam. The sole issue here is, my lord, whether the revised scale of pay adopted by the government will applicable to the employees of the corporation or not, my lord. The revised scale of pay, my lord, was by the government was issued in the year 1998, but the corporation adopted it in 2008, my lord, due to financial crisis, my lord. And the learned single judge has, in this the application, my lord, has directed the corporation to issue a modification order dated 18/2/2009 in the line of ORSSP Rules 9080 being applicable with effect from 1/1/1996. All the petitioner are, my lord, applied for the VRSS here and they are voluntarily retired in the year 2002, my lord. The revised scale of pay, my lord, applied to the employee of the corporation in the year 2008, my lord. Your lordship can have glance page 13, my lord, of the writ of appeal, my lord. Paragraph 17, my lord. Your lordship, may I read, my lord?
Yes.
My lord, office order, my lord, your lordship may can. Implementation of revised scale of pay 1998 in respect of OSRT employee. In accordance with the finance department resolution dated such and such, read with finance department notification such as approval of the government in city department, communication by letter dated 16/2/2009, the revised scale of pay 1980 is applicable to the employees of the OSRTC, including the employee erstwhile URT, O1 STS employee now on deputation only. The revised scale of pay 90 shall be effective from the 16/2/2000 with the following condition. These petitioners, my lord, were already retired from the service by getting VRS, my. So my lord, I have given a death chart, my lord. Your lordship may can have a glance to the death chart. Your lordship, in 1/5/1974, my lord, Odisha State Transport Corporation was formed as per the provision of Road Transport Corporation Act 1950, my lord. On 21/12/1970, respondent 1, my lord, was appointed as a ministerial servant, my lord. On 13/1/3/1978, my lord, state government frame OSRT employee classification, recruitment and condition of service regulation.
Who's appearing for the employees in all these matters?
Yes, my lord.
You're there for all the appeals.
In all the
All.
two cases, but I am leading the cases.
All right. Yes,
my lord. In the year 13/1/3/1978, my lord, the state government has framed Odisha State Employee Classification, Recruitment and Condition of Service Regulation 1970, in which there is no condition that the scale of pay and DA of the state government will be applicable for the employee of OSRTC. The scale of pay of the employee of OSRT were fixed as per the ORSP rules 1980 with 10% of DA, my lord. The increase in DA given to the government employee could not be allowed to the employees of the OSRTC due to poor financial condition and continued losses. In the year 1996, claim of employees of OSRTC for higher DA at par with government servant was referred to Industrial Tribunal in ID case number 140 of 1996. On 1/1/96, pay revision as per the ORSP rules 1980 was made applicable for the government employee only. The benefit of pay revision could not be allowed to the employees of OSRTC due to poor financial conditions.
When was it made applicable?
My lord, on 2008, my lord.
So from 2008, they are entitled to?
They have already retired by VRS, my lord. in the
No, that,
2002,
will
my
the
lord.
pension get correspondingly revised?
No, there is no provision pension, my lord. Provision of pension for the corporation employment.
Oh, no pension at all?
No, my lord.
Oh. How do you justify it, sir? You come to the court in 2011, correct?
My lord.
You filed these writ petitions in 2011.
Yes, my lord.
So how many? 13 years after and 3 years after revision?
No. 2009 it was implemented. Your lordship may kindly implement.
You retired in 98.
Not 98. After 98, the ORSP rules came into force
When
by
did you
the,
retire,
by
sir?
the government.
When
After,
did you-
after that, you have retired.
No.
When? That is 2002, 2003.
Whatever. So
What happened, my lord? That time, that pay fixation was not to be introduced by the corporation.
So
It was
2008
introduced-
it was introduced.
Yes, ma'am.
Why did you wait till 2011?
That was not available, so there we cannot challenge.
2008 it was available, sir.
No, that was applicable in 2009.
Okay, why did you wait for 2 years?
When it was, we have represented when they did not give.
Once you're retired, how can you get that revised pay? Once they've adopted it only in 2009.
Then I'll clarify, my lord.
Right.
We were two sets of employee. One from the STS and one from the direct recruiting. Your lordship kindly have two sets of employees are there. Two sets cases were filed. And both the cases were disposed of by common order, similar type order, that they are entitled for the benefits from the 1998. And those the employees, those have come from STS, and their case only allowed here in the writ appeal and as per the government guideline, and that's why these cases were segregated from there, and that judgment was passed. And these persons were left out only. My respectful submission, my lord, after 1974.
What is the judgment you are?
Yes, my lord.
Well, I am clarifying, my lord. There are two sets of employees.
Two sets
One
of
from
employees?
the STS, my lord,
Yeah.
who are on deputation to the corporation, and others are direct employees. And in case of STS, my lord, who are deputed,
means what?
they are eligible for
What is STS?
Yes,
well,
that-
state transport
Transport
service.
authority.
State transport service. Before
service.
my lord, before 1974, there is a state transport service, my lord.
ORT.
My lord?
ORT.
Oh yes, my lord. Odisha Road Transport and STS, my lord. They are claim and we are allowed. They have get their revised scale of pay, my lord.
So my
As per
responsibility
they
is
are
clear.
government employees.
So my responsible submission, there is a clear discrimination as because those after 1974, both the became one cadre and the same nature of a duty. And but since they were allowed the benefit, that only differential salary from 98 to till their retirement, that is 2004. That's why their cases were withdrawn as because they have been allowed the benefit. My respectful submission, I have given a judgment of this the Honorable Supreme Court regarding Article 14 in this type of case. I have that is attached with my death chart. Your Lordship may kindly see that in 2017 2 OLR Supreme Court 503. This is available with my death chart. Government has a sanctioned money for STS and others, but they mean that it is for the STS. If your Lordship will kindly see the order. And these orders are available in that 373 order. And that was segregated. That's why those documents are not available here. All were taken together. After that order, these cases are segregated from this. Your Lordship may kindly see. And this order, the government has sanctioned only for, not for STS, but for all. Your Lordship may kindly area claim. The order dated 2010-2018. Your Lordship may kindly clause 1. Claims of erstwhile employees of STS and others. So government has sanctioned money for the benefits for all, but they mean that it is only for STS. If we are in one cadre, we have been allowed similar scale, all the scale, revised scale, and they will be allowed the claim, but we will be left out. Is it not clear case of discrimination, my lord?
So how can you claim parity with STS?
As because after 1974, they came from the STS, we are directly recruited. We came into one cadre and same nature of duty and same scale of pay, and in all previous pay fixation, we have been allowed same benefit. Though in all previous stages, the revised pay scale were given later, but from the date of the implementation of the pay fixation, all we have been given. But here we have also retired, they have also been retired. And in 2009, it was applicable with prospective effect. That's why both we filed the cases. That 373 cases, and in the pendency of the case, both the cases were allowed by the Lord and Single Judge. Only one ground, if your Lordship kindly see that judgment of the Lord and Single Judge, your Lordship only one ground.
For STS people, from which state have they given it, sir?
Yes, from 1982, the date of retirement.
No. Show me an order that for STS they've given it from 98. Where is that?
No, according to this order, my lord.
What?
They are given.
Which order?
Accordingly, the case was withdrawn. The government has pleased to give them a benefit.
Have they, from which date have they given the benefit?
From 1982.
No. Show us, read, don't orally say, sir. Show us a document which says for STS employees, the benefit has been given from 98.
I may be giving some little time. I will give you
this all back. Counsel for the respondent needs some time to produce documents to show that for the state transport service (STS) employees, the benefit of revised pay scale. Employees of the OSRTC, the benefit of the revised pay scales of the state government was in fact extended from 1/1/98 onwards. Full stop. At his request, list on 21st August.
Item number 79.
Not 21st, sorry. 23rd August. 23rd August. Right.
Item number 79, my lord.
79.
Both these appeals, I have already entered appeals in respect of respondent number 2 to 5, my lord. I have already filed my Bokalanava yesterday, my lord. 2 weeks time may be given to file the reply, my lord.
No, writ appeals, no reply is required.
They are not required.
Not required. In fact, the issue is left out with some of the respondents against whom the notices are brought back.
No such addressee in that address and all that.
So in fact,
substitution that IA 392 allowed as paid for the consolidated cost that will be filed with the levy.
Right.
You say all such respondents who are yet to be served, fresh notice will be issued at the addresses to be provided by the counsel for the appellant within 4 weeks. Full stop. Where reports have been received stating a particular respondent is deceased, the appellant will take steps for substitution.
Yes.
List on.
In the connected appeal also, I will follow up the
23rd August. Both these. Right.
23rd August.
The detail is called from where we stopped. So all the other matters can wait. Run through the
weekly list. Item number 31.
The cancellation of lease matter, my lord, the petitioner is the subsequent purchaser, my lord. He was not giving notice to hear.
What's the date of your sale deed?
Is
Sell deed or date.
sale deed, my lord, 82.
86 or 82. I'm
82.
sorry. I'm sorry. 82.
On the short ground that notice was not issued to the present petitioner, who is a purchaser from the original lessee by under register of the property in question under a registered sale deed of 1982, before passing the impugned order dated 19/9/87 of the ADM Bhubaneswar, it is hereby set aside and revision case number 672 of 1987, arising out of WL case number 470 of 1974, is restored to the file of AD Bhubaneswar, where it will be listed on 5th April 2023. We'll stop on that date. The petitioner will appear through an authorized representative. The AD is requested to proceed afresh and dispose of the said revision case within a period of 4 months thereafter. Till such time, the interim order dated. Oh, there's no interim order yet. Till then, status quo shall be maintained vis-a-vis the property in question. Petition is dismissed.
Obliged. Weekly list item 32.
None appears dismissed.
Weekly list item 33.
May I please, Your Honor? Well, I have challenged Annexer 1, an order of the Labour Court. Admittedly, the so-called workman is my power of attorney holder. He looked after work on my behalf and directly approached the Labour Court under 33C2 without any predetermination. And the Labour Court entertained and passed a money decree.
Has he been served?
Yes, he is appearing.
Who is appearing for?
Mr. Jenna was appearing.
Where is he? It will stay on board. Let him come, sir.
Item 34.
Well, it is passed over, man.
Item 34, kindly pass over. Item 34, kindly pass over.
Who's appearing? On whose behalf are you seeking?
I am appearing for the petitioners. Conducting counsel.
There are two kind of matters. Management has filed some cases, and in one case, the my lord workman is a petitioner before your lordship. Listed.
The payment has been made to the workman. 17B.
In fact, entire payment has not been made. They have made some payment in the meanwhile, but they are not making the full payment. That is the whole difficulty.
My lord, in this matter, out of 4 cases, in the 3 cases, since the counsel for workmen was not appearing, this honorable court has asked me to assist the court, my lord. What I find, my lord, in these 3 cases, IA is pending to pass a similar order that was passed in 652, that is to pay the 17B wages as per the Minimum Wages Act. That petition is pending, my lord. IA is pending.
Why don't you make calculations, Mr. Mishra? Why don't you people give the calculation, then we can put it to the petitioner?
Well, I'll give the calculation. Here, my lord, in fact, 11 dues are pending.
Sorry?
11 number of dues are pending.
My lord, last occasions, my lord, I have already as per direction of the honorable court, my lord, the check I'll only hand over to the workman, my lord.
Which workman?
My lord, the OP number, the London Council, my lord, is appearing on behalf of the OP number 2 lordship in 652. And if my London senior is saying that there's 11 checks, let them submit.
He has given 3 checks on 1/2/2023 to my client who has received it. And as for the instruction received from the client, still 11 number of.
Both Mr. S.K. Mishra, Learned Counsel, appearing for the workman in writ petition civil 652 of 2012, and
in other
amicus.
I have been assisted in other 3 matters.
And Mr. So-and-so appearing in the for the workman in the other 3 matters state that the section 17B wages have not yet been fully paid to the respective workmen. Full stop. Each of them will provide the detailed calculation of the outstanding 17B dues to counsel for the petitioner within 10 days. Stop. The counsel for the petitioner will ensure that the 17B dues are fully paid to the workman before the next date. List in the regular list of matters on 4th May.
May I only point out that in WPC 652, there was a direction that the 17B wages should be calculated as per the Minimum Wages Act.
That's obviously. So when you make your calculation, you'll show them accordingly, sir.
My lord, 654 is my lord, the petition is died lordship.
654,
My lord, the WPC number 654 of
54 of 2012. Who's appearing in that?
My matter, my lord, where the workman has come up.
Sorry?
That is my matter. The workman has come up, my lord.
Against what?
Against the same award. Against the same award, challenging the part of it, my lord. That is also for your lordship.
All right. List of the same date.
Item number
Pardon to make a mention, your lordship. Pardon to make a mention, your lordship. Your lordship, sorry, your lordships, I'm not well, I'm appearing on VC. Your lordship, item number 5 of weekly list in this.
Not now, sir. Whenever we call it out, not now. Yes.
Item number 35.
My lord, in item number 35, I'm there on behalf of Mr. D.K. Mishra, counsel for the opposite party bank, my lord.
All right. None appears as the petitioner. Dismissal on prosecution.
Item number 36.
Memo taken on record. Dismissal on prosecution.
Item number 37.
On behalf of K. Guru, next week. His house.
We're not adjourning it. We're not adjourning it, sir. Proceed with you have the book.
No.
Dismiss for non-prosecution.
But
Yes.
the opposite party.
All right.
Item 38.
None appears dismissed.
Item number 39.
Memo taken on record. Dismiss is withdrawn. All the wherever the memos are, you just take it, call out.
Item
Just-
39, 40 and 41.
Ah,
42.
yes. We'll
Item
continue
number
after.
43.
All right. None appears dismissed. Stop. Call out. So can we wait for a few minutes? We'll just run through the weekly list and then start. Or is everybody already there? Oh, it's tomorrow. Oh, I see. Sorry, sir. I made a mistake. All right.
Weekly list item 44.
May I please, my lord? My lord, in this case, the facts of the petitioner before the learned tribunal is that since he was working as a clerk cum typist since 6/3/93 to 31/5/2009, his services were not regularized, and in the year 2009, his services were dispensed with, my lord. Pursuant to that, he raised an industrial dispute to which one reference made. And my lord, the reference is at, kindly have a glance to page 17.
Yes.
My lord, may I read that?
Yes, please.
Whether the refusal of employment Sri Tara Prasad Bhanja, casual clerk, cum typist by the executive engineer, Rural Works Division, Chandrasekharpur, Bhubaneswar, with effect from 1/6/2009, is legal or justified? If not, to what relief Sri Bhanja is entitled? My lord, during this hearing before the learned tribunal, the second party has examined himself as WW1 and exhibited as 1 to 11. On the other hand, first party has examined 3 witnesses and has exhibited documents which are marked as Exhibit A series, my lord. My lord, what happened during the proceedings before the learned tribunal? The finding by the learned tribunal is that he disbelieved one exhibit which was exhibited as Exhibit 2, in which one list was drawn where it has been shown that the petitioner has worked from since 93 to 2009, my lord. That exhibit has been disbelieved by the learned tribunal. And my lord, that exhibit 2, and during the adjudication, the petitioner also relied upon certain exhibits which he availed through RTI Act, my lord. That is also discussed. My lord, kindly now peruse the documents which are before the learned tribunal. My lord, that is at page 12. My lord, found that page,
Yes,
my
yes.
lord? My lord, this is a letter that has been made from Chief Engineer, Rural Work Division to all executive engineer, my lord. Here it is categorically written, as non-finalization of the said list have been viewed otherwise during the course of pre-budget scrutiny meeting, you are requested to please go through the records of the subdivision sections and furnish final list of such category of workers in the said pro forma by 7/1/2003 positively. It may be informed that delay in the matter will not be entertained under any circumstances and will be recorded in the CCR of the defaulting officers. My lord, thereafter, kindly have a glance to page 11. That is a continuation letters. My lord, that is on 7th January 2003. My lord, found that page, my lord?
Yes, yes.
My lord, in that letter, Executive Engineer, Rural Work Division, communicated to the Assistant Executive Engineer, Rural Work Subdivision, my lord, that in that letter, it was categorically written to submit the required information by 4/1/2003 with a certificate that personally verified the record and found correct. And my lord, in the last enclosures are 30/12/2002 is enclosed. My lord, thereafter, page 12, page 10. My lord, here also Assistant Engineer Rural Work Subdivision communicated a letter to the Executive Engineer that the service biodata of DLR, NMR, HR category employees working pertaining to 4 sections under this subdivision is prescribed pro forma for taking decision. My lord, at the bottom, it is received 16/1/2003, 315. The enclosures, my lord. The pro forma. My lord, now what is the pro forma is, which was exhibited to, that is at page 15. Kindly have a glance. My lord, serial number 1. My lord, found that page serial number. That is Tara Prasad Bhanja, the petitioner herein. My lord, at the bottom, it is clearly written, certified the above statement are correct, and in working in subdivision office on daily basis. My lord, there is a counter signature of Junior Engineer, Rural Work Secretary Khurda, Assistant Engineer, Rural Work Subdivision Khurda. My lord, this is the letter which was disbelieved by the learned tribunal. My lord, now kindly have a glance to the finding of the tribunal. My lord, before going to the finding, my lord, I want to place what is the exhibit 2 and 7, 8 and 9. Since he has disbelieved exhibit 2, he has also disbelieved exhibit 8 and 9, which categorically stated that the petitioner has worked during that relevant period. My lord, kindly have a glance to page 22.
Yes.
Exhibit 2 is a statement signed by the junior engineer as well as the assistant engineer of Khurda section, which reflects that the second party working as a clerk cum typist in the subdivisional office and his date of engagement is 6/3/93. Exhibit 8, which is an enclosure of Exhibit 7, is also a statement signed by the Junior Engineer Rural Work section, where it is mentioned that second party was engaged in typewriting work in the subdivisional office and his date of first engagement is 6/3/93. And also in Exhibit 9, a gradation list which is signed by the Junior Engineer Rural Works, Khurda, the same facts are mentioned. And Exhibit 10-11 series of the official letters originating from the subdivision office, my lord. My lord, now kindly come to the para 7. Now let the reliability of these documents be examined, explaining as to under what circumstances the name of the second party has appeared in Exhibit 2, a pro forma signed by MW number 2. The witness, management witness number 2, admits to have issued Exhibit 2, but takes the plea that when he prepared the document, he had not verified any office records to get himself confirmed that second party had been actually working since 6/3/93. He has stated that he submitted Exhibit 2 to the assistant engineer merely on an application made by workman. MW2 has further stated that he was posted as junior engineer in the rural work section, such and such, my lord. My lord, on the basis of this, my lord, thereafter kindly have a glance.
I think those sentences are important.
My lord?
Continue.
Pardon, my lord?
Continue it.
Yes, my lord. Conclusion is that
Where she left off.
the vital documents.
Continue reading from where you have left off.
My lord.
Further you read. You continue reading. Don't leave it.
Yes, my lord. He says that, that is, my lord, I stopped here. Workman, MW2 has further stated that he was posted as the junior engineer in the rural work section, Khurda, from September 98 to June 3. He says that during the period, no payment was made to the second party from any funds allotted by the government. According to him, he used to engage the second party as and when required to type out letters, and for the said he used to make payment from his own pockets. As it appears from his testimony, the witness was not attached to the section office prior to 1998. Therefore, when he has prepared Exhibit 2 without verifying any official records, then it can be presumed that information contained in Exhibit 2 is not authentic. When he says that Exhibit 2 was prepared by him, submitted before his assistant engineer, merely on an application made by the second party, it is to be presumed that MW number 2 was officially not required to prepare a statement like Exhibit 2. The second party has obtained the copy of the statement, but he has not obtained the copy of any such document showing the statement marked Exhibit 2 was officially forwarded to the first party executive engineer in due course of official business. Exhibit 2 came into existence on 16/1/2003. The second party claims to have worked continuously since 6/3/93. There is no document on record that originated in between 93 and 2003, showing that second party had actually been working since 93. The second party has exhibited a series of letters marked Exhibit 10 series and 11 series. He has obtained these letters by making an application under the Right to Information Act. He claims, and it is not denied by the other side, that these are the letters which he had typed or written under the instruction of the junior engineer, assistant engineer, Khurda section. These letters are on different dates starting from 1/2/2002 to 25/2/2009. The second party has not exhibited any other letters of similar nature to show that he had written such letters prior to 2002. Thus, there is no material to show that second party was engaged in section office prior to 2002. For all these reasons, it is very difficult to place reliance on Exhibit 2.
What do you have to say to all of this?
My lord? My lord, my humble submission before your lordship is that he entirely disbelieved Exhibit 2. And which has been admittedly prepared by the management witness, my lord, before the learned tribunal. and that was disbelieved. And that was a continuous letter which has been communicated to the subdivisional office with regard to the appointment of the petitioner, my lord. And since he disbelieved exhibit 2, he disbelieved exhibit 8 and 9. That is the finding, my lord. My lord, I have shown that exhibit, my lord. It is clearly, my lord, it is countersigned by both the management witness, my lord.
Yes.
And that has been continuously the communications of letters, my lord.
If you have any pay slip that you are paid any salary, normally these are government establishments, right?
Yes, my lord.
There's no question of receiving payment without a pay slip. Whatever register, something, some payment
That
register.
was not exhibited.
Ah,
My lord, but this is the only document which has
that's right. That's the
shown in
problem.
my favor,
That's
my
the
lord.
problem.
My lord, because in this, with regard to the veracity of this document, the
Yes.
learned tribunal has failed to come to a
Yes.
conclusion in an
Correct,
illegal
correct,
way, my
correct,
lord.
correct.
Because these are DLR and NMR employees, my lord. My lord, in this way, they used
Also,
to...
the very persons who prepared the documents, they were examined, they were not prepared to support those documents.
My lord, they have said that they have prepared this document.
No. The man says, I did not verify any details, and the same man says we used to engage him on work need basis.
My lord,
the same person who prepared the document.
My lord, I bow down, my lord. My lord, but... My lord, can
And that he is paying him from his own pocket.
My lord, can I submit, my lord? My lord, these documents, then how can he forward it to the executive
Exactly. So the
engineer?
person who writes those documents is not prepared when he gets into the box to support those documents. You expect the judge to then disbelieve him, the person who's written the document, and he tells the judge, I did not verify before I wrote the document. You are now asking the judge to disbelieve that witness and still rely on the document. This is really extraordinary.
My lord, because this is the document which shows my...
But the person who wrote the document is not prepared to support the document.
My lord, because on my representation, since my name was not there, this document was prepared.
That's what transpires, that at your request, he prepared a document.
Because
then what does it mean
lord,
when he tells the court that at his request to prepare the document?
My lord, can I not raise my grievance through this representation since I work?
See, ultimately, when you go before a labor court,
yes, my lord,
there is a process of leading evidence, correct?
Yes,
and you have to prove documents as known in law. How do you prove a document? By examining the author of a document.
Yes,
so the author of the document has to say, yes, I prepared this document, and this reflects correctly what the position is. Unfortunately for you, the author of the document gets into the box and says, I did not do any verification before I prepared this document. Second, I prepared this document at the behest of this person. Third, he says, no, I engaged him on temporary basis as and when I needed some typing to be done. Fourth, he says, I paid him from my own pocket. And now you're saying, no, this witness should be disbelieved. And the court should somehow say, notwithstanding that the author of the document has abandoned the document is still correct and should be believed. The problem.
My lord, can I pray that this matter may be remanded?
Remanded for what? No. No new witness is going to appear to support it, right? The challenge of the present petition is to an award dated 9th December 2011, passed by the Industrial Tribunal Bhubaneswar in ID case number 9 of 2010, answering the reference against the petitioner workman. Paragraph, the following issue was referred to the tribunal for its decision, reproduced from page 17 bottom. Paragraph, the case of the petitioner workman was that he had been engaged from 6th March 1993 onwards as clerk cum typist under the direct control and supervision of the junior engineer, rural works section, Khurda. Full stop. He's supposed to have worked continuously up to 31st May 2009 without a break. But when he made representations about his name not being included in the gradation list, he was verbally refused employment with effect from 1st June 2009. Stop. He claimed that his retrenchment was contrary to Section 25 Capital F of the Industrial Disputes Act 1947. Paragraph. The opposite party management denied having ever engaged the petitioner. Full stop. It was submitted that although the name of the workman did appear in a list submitted by the Rural Works Section Khurda, there was no record in the division office showing that he was ever engaged by the management. Full stop. In the final gradation list of the different subdivisions, the name of the workman did not figure, and he did not file any objection against his non-inclusion. Paragraph. While the workman examined himself as a witness on behalf of the management, MW2, who prepared Exhibit 2, that is a statement of the junior engineer, countersigned by the assistant engineer, reflecting that the workman was engaged as a clerk cum typist in the subdivisional office, was examined. Full stop. Unfortunately for the workman, MW2 stated that he had prepared Exhibit 2 without verifying any office records. Full stop. He further stated that he had forwarded it to the assistant engineer, open quotation, merely on an application made by the workman, unquote. Full stop. MW2 further stated that during the period when he was working as a junior engineer, that is September 1998 to June 2003, open quotation, no payment was made, unquote, to the workman from the funds allotted by the government. Stop. According to MW2, he used to engage the workman, open quotation, as and when required to type out letters. And for that, he is to make payment from his own pocket, unquote. The tribunal, on an appreciation of the above evidence, concluded that Exhibit 2 was not a reliable document. And in any event, there was no other document to show. And that it, full stop, it was noted that it came into existence only on 16th January 2003. There was no document to show that the workman was working continuously from 6th March 1993. Paragraph. Exhibits 8 and 9 have been prepared on the basis of Exhibit 2. Full stop. The evidence of MW3, another junior engineer, who was supposed to have prepared Exhibit 8, showed that no payment was made to the workman from out of government funds. Full stop. The impressed cash account, bracket Exhibit A series, bracket did not reflect any payment being made to the workman during the entire period of his engagement as claimed by him. That is 6th March 1993 to 1st June 2009. MW3 further stated that Exhibit 9 was not part of any official correspondence, and the facts stated therein, open quotation, were not obtained from any office records. Unquote. Paragraph. Therefore, unfortunately for the workman, the authors of the official documents, purported official documents sought to be relied upon by the workman, was not supported by the authors of those documents. Full stop. The tribunal therefore came to the inevitable conclusion that they could not be relied upon and did not support the case of the workman. Paragraph. Having heard learned counsel for the petitioner, the court is not persuaded that the tribunal has committed any error in holding that the case of the workman did not stand established by the evidence laid before the tribunal. Paragraph. No grounds are made out for interference with the impugned award. The petition is dismissed.
Weekly list item 45.
I am for OP1.
May I please, Lordships? In the present case, the petitioner has grievance that even though he was appointed and completed more than 240 days and has completed continuously 1 year, his service was terminated without following principle of natural justice and by way of a refusal to work. This is my case. My lord, he was appointed as a watchman in a ladies' hostel and continued from 15/7/91 to 10/7/92. He worked continuously. Thereafter, he was denied. And he was given assurance, and a rock sound assurance, that he will appointed as and when will feel necessity or anything of sort. But I come to know that after my departure also they have given appointment to somebody else. But I have been terminated without following the principle of natural justice. Then, my lords, he filed a complaint petition before the conciliation officer, and that ended in a failure. And it was sent to the government. And ID case number 197 of 1990, it was filed. And thereafter, the case started. Twice the management remained ex parte. Twice the judgment was expert judgment was passed, and thereafter, and it was allowed, and he approached the honorable court, and it was quashed again. This is last time this present case has been filed. So, my lords, only my grievance is, my lords. Only I pray, my lords, to kindly see my annexure, page 9, annexure 1. Annexure 1, that this is to certify that Sri Pradeep Kumar Dhar, myself, son of Sri Kangali Charan Dhar of village Nihal Prasad, post Nihal Prasad, district in Henkanar, was working as a watchman on monthly contract basis in a ladies' hostel of this institution for the period from 15/7/91 to 17/7/92. It has been given by the principal Grama Sevak Talim Kendra, Bhubaneswar. My lords, this is a admitted and undisputed fact that I have worked for 1 year, and that is from 15/7/91 to 17/7/92. Thereafter, they have also given appointment to other things. I will come to my later, my lords. This is the certificate which indicates I was a worker in that organization. Only, my lords, but I have in annexure 2, I have vividly described what has happened to my lords. That is page 10, annexure 2, my lords. That the second party, myself, second party workman has performed continuous service for more than 240 days in the relevant year, which constitute 1 year of a continuous service under section 25B of the ID Act. that the first party management terminated the service of the workman on 17/7/92 arbitrarily without a prior notice or any reason. He has also not been paid the due compensation required under law. In fact, provisions of Section 25A of the ID Act 1947 has not been complied with by the management prior to the termination. The workman has performed his uninterrupted duties most satisfactorily and diligently, and there is no stigma during his service career. That neither charge sheet has been framed against him for the misconduct committed by the workman, if any, nor inquiry has been conducted. In effect, principle of natural justice has not been followed. Before the termination, that suddenly the first party management, out of his whims and fancy, refused the workman employment from 17/7/92, and thereafter he was not allowed to do his duties. The termination of service by way of refusal of employment amounts to retrenchment under Section 2 of the ID Act 1947. That it has been stipulated in the aforesaid provision of law that termination of service of a workman by the employer for the reasons whatsoever, except the exclusion made therein is retrenchment, and it is mandatory on the part of the
Mr. Patnaik,
my lords.
Para 8 of the award.
Para
8 of the award.
Para 8 of the order. Para 8, yes. 8. That suddenly on the first party management, out of which whim and fancy, refused the workman
Page
employment.
31. Page 31. Para 8 of the award.
My lords, award.
Page 31.
In commitment. Para 8, my lords. Did we para 8 shall I read? Yes. On a perusal of Exhibit 1, Xerox copy of one experience certificate, it appears that the same was executed by the principal Gram Sevak Talim Kendra, Bhubaneswar, on the 9th November 1996 in favor of the workman. Even if this document Exhibit 1 is accepted in its totality, it only shows that the workman was working on a monthly contract basis as watchman for the ladies hostel of the institution, that is a Gram Sevak Talim Kendra. From this, it appears that Exhibit 1 does not prove itself that the service rendered by the workman was continuous and as defined in Section 25B of the Industrial Dispute Act 1947. There is no material on record to show that the workman was in continuous service as defined in Section 25B on the Industrial Dispute Act 1947. No doubt, the onus heavily lies on the workman to prove that he was in continuous service as defined in Section 25B of the Industrial Dispute Act 1947. In the instant case, except oral evidence of the workman coupled with the experience certificate, Exhibit 1 does not lead to any definite conclusion that the workman had worked under the management for 240 days in the period of 12 calendar preceding to the date of his termination as defined in Section 25A of the Industrial Dispute Act 1947. Therefore, it cannot be said the workman is entitled to get the benefits of Section 25A of the Industrial Dispute Act 1947. Hence, order the action of the principal Institute of Management of Agricultural Extension, Bhubaneswar, in terminating the service of Sri Pradeep Dhar, watchman.
Para 8 is the conclusion on the basis of the...
My lords, with all respect and courtesy, I would like to submit. I am a watchman. My qualification is not that what is expected, like any other things to appear to be appointed in any other post. There is no such provision that unless one pass matriculation or IR or BA, he will be appointed, and he should have minimum common sense to get something or to extract that he is continuing or continuous service is necessary as per 25A. Has there any document, or could they say any document, or could they produce any document before the court that they had given, they used to give any appointment or any appointee these documents which he does not possess. But what about the principal who has given the document? Have they asked the principal that he has not given, but a false document has been given? Things must be done in the manner it should be done, not in any other manner. So, my lords, that is why natural justice is there, which my lords always says natural justice must be followed. Which honorable apex court hold, natural justice must be there. The fact is, my lords, the fact is that I have worked there and I have completed 1 year, which they have admitted. But now they say in that para that I have not produced any document. What document were there? What document they could show before the court to satisfy that the documents which are necessary, the document which is the...
It is other way around. You have to prove, not they.
Yes, I have to prove. And what I have,
You have only produced the experience certificate.
Yes, have they asked any other documents which I could not prove? I have produced, or have they say that the rules, regulation, or oral instruction, or many things would prove that these documents are necessary, which he could not show, my lords. I have given oral evidence, my lord, there, and they have accepted it. I have not told lies anywhere else. Now they say, my lords, with all respect, I would like to put a question to myself. What is natural justice? Why they did not take the help of the natural justice? Why they did not produce a single letter to me that you have not worked, or you have neglected, or your conduct, you have borne a misconduct? That is why should your service shall not be terminated? What has prevented them, my lords? Only I want to put this question to myself. And it is my lords who will only be satisfied that the employer has taken all possible steps to see, show, and satisfy that actually he is not fit person to be appointed, my lords. I am coming to my... So that is my lord. They say, my lords, para 7, my lords, I may be permitted to read out. During the course of a hearing, workman, in his affidavit, evidence has stated that he joined in this service under the management as a watchman on the monthly wage of 750 with a effect from the 15th July 1991, and he worked as such till the 17th July 1992, when the management terminated his service by way of oral refusal of further employment. My lords, kindly say, I put a question to myself. By way of oral refusal, what obstructed them to give in writing that your service is terminated because of this, or your service is terminated? No, they will not take any kind of a risk. They know how to extract work, and they know how to harass the poor people like us or like our category. He has further stated that no charge has been framed against him and no inquiry has been conducted prior to refusal of his employment, and at the same time he has stated that the management did not issue any prior notice and did not give any notice, pay and a retrenchment compensation before his service was terminated. He has further stated that the management has retained the service of some junior watchman in his place, and he denied the allegations of the plea taken by the management in his written statement. The workman has not filed any document during the course of a hearing after the case was remanded to this court by the Honorable High Court of Orissa, Cuttack. But at the same time, on perusal of the case record, it appears that the workman has filed a document, that is one experience certificate, and a proof that the same as Exhibit 1 on the earlier occasion. On the other hand, the management adduced one evidence, Sri Rajkishore Naik, and corroborated the fact stated in his written statement. Nothing has been recited from the mouth of the MW1 to discard his testimony. I am a watchman, nothing more. They are the principal, and the principal has given a certificate that I was working continuously for 1 year. Should it be disbelieved, my lords? Is there any document to disbelieve that certificate given by the principal is wrong, defective, manufactured, or anything of such? So why should he not take into consideration that certificate? It is my prayer, my lords, to kindly consider this one. Therefore, my lords, I do not want to waste my lords' time. Only I would like to say and show simple thing art is held by the Honorable Apex Court and also my lords, that justice is not only be done, but also appears to be done. If my lords says or is satisfied that justice has been done and it appeared to be done, I have nothing to say. In addition to this, my lord, the appearance of injustice is a denial of justice. I would like to repeat it. The appearance of injustice is a denial of justice. In this present case, what appears? They have not issued show cause. What has it prevented, my lords? Only I want to get a reply. That my lords big reply to that. What is the difficulties for which they could not submit a piece of paper to them that you have committed this mistake? So it clearly indicates it is injustice. So how can I get justice? In addition to this, my lord, the aim and object of natural justice is fair play and fair action. Is it my fair play and fair action? Their employer, they're not educated, but they're highly educated. They are in power, but they have behaved this way, in this manner. So it is not indication of non-application for judicial matters. What more a poor man can do it? They said they will call you when we will feel necessary or anything of sort. They did not give me writing, but they terminated my service. Furthermore, my lord, the management has never pointed out that I was irregular or I remained absent without intimation or without any information. Nothing absurd. No allegation of any kind has been shown to satisfy that something is there. Manners, page 21 manners. I will give you clear 21 manners. Evidence and affidavit. I am Sri Pradeep Kumar Dhar, myself. I was appointed as a watchman by first party management on 15/7/91 with a consolidated salary of 750 per month, being selected in an interview and posted to perform my duties at Grama Sevak Tamil Kendra under the control and supervision of this management. In course of my employment, I discharged all my duties very sincerely and satisfactorily. And during my tenure
whatever you have submitted, that has been already there in the evidence.
Yes, that I want to say on affidavit has written it. Neither I have neglected my duty, nor I say I have put forth some false thing before my employer. Nothing of sort. But the learned court below reaches at conclusion, I have not shown or produced any document. What more greater and better document than these, my lords? It is for my lords to consider. Here, may just tell one sentence more. While working as such, when I reported to my duty on 17/7/92, the management verbally told me that the management has decided not to retain my service anymore henceforth and thereby refused my employment with effect from 18/7/92. The management at the time of termination has neither served any notice nor paid the notice pay in lieu of the notice and any compensation as required under section 25F of the Industrial Act 1947. The management has retained service of some juniors to me in as much as has appointed an outsider or fresher in my place. After being terminated from service, I approached the management and requested for my reinstatement, but my grievances were not redressed. At present, I am unemployed and not gainfully employed anywhere. I pray for reinstatement in my service with the service continuity and other consequential benefit. The engagement or appointment was not a contractual appointment for any specific period as alleged by the. So, my lord, see here, after I gave or informed it, is there any other documents or essential documents or important documents are necessary to reach at the conclusion that natural justice has been followed? Only I put the question myself. Why should the natural justice not be followed? Why have they not followed the natural justice? That should be explained by the management to my lords. So with this, I pray, since the injustice has been done, justice should be done, my lords. That is why it has been held by this. Any kind of illegal display of injustice is a denial of justice.
All right, we'll pass the order. Dismissed, we'll pass the detail order. All right.
Item 46.
I beg pardon, my lord. Item number 38, I could not be present.
Afterwards, whenever you call out. Right.
Item 46.
46, I am for the bank.
All right. None appears to the petitioner, dismissed.
Item 47.
47, my lordship, the impugn demand notice under annexes 7 and 8. It covers the corporate insolvency resolution plan, my lordship.
All right. Court is informed that in view of the corporate insolvency resolution plan finalized for the petitioner by the NCLT in proceedings instituted under the Insolvency and Bankruptcy Code, the impugn demands stand covered by the said plan, and therefore no further orders are required in that regard. The petition is disposed of. Both matters.
Item 48.
None appears dismissed.
Item number 49.
OP number 3, my lordship. None appears to the petition, dismissed.
Note 50.
And for the petitioner, your lordship, for the convenience, the second item which was listed, WPC 5180 up to the same may be taken out first.
All right. You can't go to the ombudsman, sir, against the grievance redressal forum.
GRF.
Against the GRF.
My lord.
Don't you have a remedy before the ombudsman?
No, madam. As a licensee, I don't have a remedy before the ombudsman.
I see.
I have prepared a short written note with the date chart. Well, here, annexure 14, as at annexure 82, annexure 14 at page 81 is under the challenge, wherein the learned GRF has arrived at the conclusion to treat the consumer as MI consumer.
Who's for the electricity department?
I am for the electricity department, petition.
Who's for the consumer?
Yes, ma'am, I am happy.
Are you not aware this erroneous bills when somebody goes before the GRF?
Yes.
No appeal is preferable for the ombudsman.
Yes, ombudsman, the consumer can go in appeal. So GRF has allowed my complaint against which they have referred this petition.
I am for the license.
Can they not go before the ombudsman?
No, the regulation and the act only permits the consumer to.
I see, not the
license
company.
My lord, here the ombudsman has held that that consumer is GRF has to treat GRF has treated the consumer as MI consumer instead of large industry. On this question, my facts arises from the short question. The consumer, while
availing the power supply, it was detected that his MD has been exceeded. He was initially drawn power supply on 90 kilowatt. And on inspection, it was held from the meter reading that he has exceeded his MD from 90 to 120. That is why the licensee has made a proceeding under Section 126 and also called upon him to execute a fresh agreement for the 120 kilowatt. Instead of, he has also admitted in his reply that due to some reason or other, that same has been exceeded.
Sir, before you continue, what is the date of the impugned order of the GRF?
25/10/2012.
When did, now next question, when did we grant a stay of that order?
Okay, I have. First, I think there is no stay.
Third question, no stay of this order for the last 11 years.
My lord.
Have you implemented this order?
No, my lord. We have not.
Why, sir?
Because he has not complied. On the other hand, he has dismantled his power supply.
So why are you bothered to challenge then? He has not complained. He has not asked for implementation of the impugned order. Why are you aggrieved?
Because there is an order against us.
You are not bothered to implement it. Why are you bothered? For last 11 years, you have never implemented it. Why are you aggrieved? You are very happy, sir. You did not get a stay from us. You never implemented the order. Nobody is complaining. He's also not complaining.
Notice was issued.
So what? Everybody is happy, sir. Why should we suddenly disturb the happiness of everybody? You are happy because you did not implement. He is not unhappy because you did not implement. Why should we add to either your unhappiness or his unhappiness?
Consumer had gone to ombudsman for implementation, but that application was dropped because of pendency of the repeats.
Very good.
And in my counter also I have stated they have almost complied that order by revising the bills. But and it was found that the consumer is entitled to get refund of 33,000 apart from security deposit.
How much refund you'll get? 30,000.
33,000 apart from security deposit of 1 lakh rupees.
All right.
Only because of pendency, they have not credited that amount and not refunded.
My lord, your lordship can hear whether a consumer who has enhanced the CD from 90 to 120 and is attracted under 126%.
I have an even more fundamental question of law. Whether a party against whom an order is passed and which order has not been stayed can afford not to implement that order for 11 years. First question.
For that, he as per my learned friend's submission, he had gone to the ombudsman. Ombudsman had dropped the proceeding due to pendency of this case.
No, you seem to have implemented, sir. You stopped short of implementing fully.
Because he has not paid the assessment at dues and also not executed the agreement till date. Till filing the repetition, he has not agreed. Your lordship, I have filed annexed enclosed the judgment of your lordship, wherein your lordship has held that enhancement of CD is attracted to 126 proceeding, wherein the licensee has done and he has to comply. I have enclosed the judgment of your lordship. So he has bound to pay the 126 assessment dues, and thereafter he has to execute the agreement for 120 kilowatt. He has not done so, and it is his admission. Your lordship can have a glance to the. I may be permitted to read my date chart. Your lordship can have the 11/6/2000 power supply was available. Application for revision of bill. And 10/2009 HT meter was installed. 13/11/2009 letter calling upon the consumer to pay rupees 2,08,400 as assessed for the unauthorized enhancement of CD in violation of CD in availing 120 kilowatt as against the approved contract of 90 kilowatt, and further execute a fresh agreement depositing rupees 3,16,080 with a period of 7 days. reply of the consumer admitting the enhancement of contract demand with explanation. Your Lordship kindly have a page 53 of my brief. Page 53. It is his explanation. Page 53. With due respect, I beg to state that we had received a letter that has subjected that we are using unauthorized enhance the contract demand from 90 kilowatt to 120. But we want to inform you that due to some unavoidable condition for repairing for machinery in the plant with some construction work for the last 3 to 4 months and also for the failure of the capacitor band, which is out of our knowledge and caused the contract demand had increased suddenly from 7.9 to 10.9. He admits. Hence, we have installed capacitor bank, and from the month of November, we are in control. Please, you may keep watch on the same. Gradually, your contract demand will come to the limit by 2 to 3 months as per the agreement of 90 kilowatt. We are now entrepreneur struggling. So he has already admitted that enhanced contract demand has enhanced. So once it is enhanced, the license is bound to call upon him to raise the proceeding under 126, to which he has license has done it, and also called upon to execute the fresh agreement. Instead of availing those things, instead of paying the assessment, he has approached the GRF, and GRF in his order, your Lordship kindly have a glance to the order. I have also quoted the relevant findings. Your Lordship, 82 page. I am reading out. Para 4, the complainant MS Impacts Ware, KB Complex Station Road Kotak is a MI HT consumer with, once it is MI, it cannot be HT. Consumer with a CD 90 kilowatt. It is a consumer since 11/6/2000. The LTT meter was fixed on the LT side of the transformer owned by the complainant. So transformer loss was included in the bill. The complainant objected to the bills from the very beginning. Then HT metering unit was installed on 10/2/2009. Then after consumer grievance for addition of transformer loss was redressed, the OP has committed no mistake by adding the transformer loss since it is a MI consumer and metering has been done at LT side of the transformer before the installation of HT metering unit. Regulation 93(9) empowers the OP for such action. The OP in its submission has stated that from 6/9/2009 observed that complainant is drawing 120 kilowatt of load, which is more than CD 90 kilowatt contracted. Due to such unauthorized enhancements of load, the complainant was assessed under section 126 of the 2003. Though forum has no jurisdiction to adjudicate the matter concerning to 126 of the Act 2003, but unauthorized enhancement of load leading to change of classification do not attack the provision of the Act for assessment, which shows high-handedness of OP and harassment of the consumer liable to drop to render natural justice. The OP is always at liberty to initiate action under regulation 82 of the 2004 for enhancement leading to change the category. But so long as complainant is in agreement with the licensee to avail supply MI category and agreement is in force, the OP cannot bill it in LI category without terminating the agreement. So how can when we have called up him to execute the fresh agreement under 120 CD, so how can you terminate and he is availing the power supply? So this finding, unless until terminated, we cannot enhance the CD or classification. That is totally unwarranted and without the contrary to the provisions of law. So we have demanded and called upon. He has not paid the amount. So this finding and order is totally contrary to the regulations and act. And the consumer GRF, which is a statutory forum, is bound to follow the statutes and as per the provisions of law. Which 126, so also the execution of agreement, of fresh agreement, he has not done till filing of the consumer complaint case before the grievance redressal forum. So how can you terminate? And the learned forum below has stated that it is terminated unless until it terminated, it cannot be done. So that question or findings of the learned fellow is totally irrelevant and without contrary to the regulations. So this finding has to be drawn and the order of the GRF has to be set aside.
Sir,
my lord,
you're finished?
Yes.
Challenged by the executive engineer electrical in this writ petition is to an order dated 25th October 2012 passed by the Grievance Redressal Forum Sesu Katak in CC case number CDD-2 bracket /424 of 2012 filed by the respondent complainant. Paragraph. At the outset, it requires to be noticed that in terms of the impugned order of the GRF, the petitioner was to revise the bills, energy bill of the respondent complainant within 15 days of the receipt of the said order. Stop. Although this petition was filed on 5th March 2013, till date, there is no interim order passed by this court staying the operation of the impugned order of the GRF. Yet, admittedly, the petitioner has not implemented the said order. Full stop. Paragraph. Counsel for the complainant informs the court that for the non-implementation of the order of the GRF, the complainant did go before the ombudsman, but only because the present writ petition was filed, those proceedings were dropped. Full stop. He further informs the court that the petitioner has in fact prepared the revised bill, but has not acted upon it on account of the pendency of the present writ petition. To stop. In terms of such revised bill, the complainant, according to counsel, would get a refund. Paragraph. One of the grievances pointed out by learned counsel, the petitioner, is that the respondent complainant consumed electricity far in excess of the contracted demand, bracket CD, and also declined to pay the enhanced energy charges.
Assessment charges, my lord. Not enhanced energy charges, assessment charges.
Full stop.
126%.
This led to the complainant being assessed under Section 126 of the Electricity Act 2003. Paragraph. The GRF has noted that an LTTV meter was fixed on the LT side of the transformer owned by the complainant. Full stop. The complainant had objected to the bills right from the beginning. Full stop. As far as the allegation regarding enhancement of the load, it was rightly observed by the GRF that it has no jurisdiction to adjudicate the matters in that regard. Liberty was granted to the present petitioner to initiate action under Regulation 82 of the Electricity Code 2004 for enhancement leading to change of category. Full stop. In other words, the GRF was prepared only to enforce the agreement under which the HT category supply of electricity was made to the complainant. Full stop. It accordingly quashed the bills raised by the petitioner by treating the complainant as belonging to the large industrial category. Paragraph. Having heard learned counsel with the petitioner, the court is unable to find any error having been committed by the GRF, particularly since on the specific issue of enhancement of load, liberty was granted to the petitioner to proceed under Regulation 82 of the Code 2004. Full stop. It was further noticed by the GRF that the complainant surrendered its supply on 29th June 2012 itself. And by that time, the initial period of supply was already over. Full stop. There was no occasion for the petitioner to have disconnected electricity supply thereafter on 31st July 2012 or require the complainant to pay any charges after 29 June 2012. Paragraph. For all of the aforementioned reasons, the court finds no grounds
with respect, we have already
with the order of the GRF.
We have already submitted final bill. As that annexure, we have already filed final after the dismantling.
All right, just call out the next. Which is the connected matter, sir? What is the next?
That is also arising out of this present proceeding, connected matter to this.
No, that is not present proceeding. That is a separate complaint filed for petitioner. A consumer made an fresh application for new connection that was rejected on the ground that it is not feasible, which the GRF didn't accept and directed for giving new connection of 25 kilowatt load. That is WPC 6643. That is a separate complaint.
The connected complaint 6643. You say the earlier matter is 5180. 6643, you say this petition by the executive engineer says so is directed against an order dated 21st January 2013 of the Grievance Redressal Forum, GRF, Cuttack, in CC case number CDD-2/561 of 2012. Full stop. The grievance of the respondent complainant before the GRF was that the petitioner had declined to grant a new connection despite the complainant depositing the requisite fees and despite the officer of the petitioner preparing a feasibility report indicating that it was technically feasible to give a 25 kW connection to the petitioner. Full stop.
Your Lordship, the Lord GRF.
The GRF has, after appreciating the submissions of the present petitioner,
I refer to para
come
9
to the
of the
conclusion that there was no justification for the petitioner to have declined to grant connection, particularly when all the required charges were paid by the complainant. Full stop. Having heard learned counsel for the parties, the court is unable to find any error committed by the GRF in directing the petitioner to provide a new electricity connection for 25 kW (LT) to the respondent complainant. Full stop. No grounds are made out for interference. The petitioners.
Item 51.
51, my lord, no instruction.
No instructions dismissed.
Item number 52.
52, my lord, no instruction.
No instructions dismissed.
Item number 53.
Item 53 on behalf of Mr. Escapade, senior advocate, my lord. He is favoring some will to
All right,
I pray for 1 week after.
Item 54.
Interim order to continue, my lord.
Item 54.
May I please your lordship? The impugned order under Annex 2 and 3 is under challenge before your lordship on the ground solely that without any notice and without any opportunity of a hearing to these petitioners, the impugned order have been passed behind their back. Number one. Number two, your lordship, against the dead person in whose favor lease was granted in 1975, who died in 1980. This the impugned order has been passed in 1990. I have prepared a small death chart, your lordship.
You're a subsequent purchaser, or what are you?
We are the purchasers. This
What's
land
the
was,
date of the sale deed?
but this land was leased out in 75.
Sale deed date kete kaun?
Sold it 1986.
And what?
Prior to the order.
All right. On the short ground that no notice was issued to the present petitioners, who are the subsequent purchasers, who are the prior purchasers, from the original lessee and registered sale deed before passing the impugned order dated 1st February 1986 by the Additional District Magistrate Bhubaneswar, the said order is hereby set aside, and revision case number 508 of 1983 is restored to the file of the AD Bhubaneswar, where it will be listed for hearing on 10th April 2023. To stop on that date, the petitioner will appear along with a downloaded copy of this order. The ADM is requested to proceed in the matter afresh and pass a reasoned order within 4 months thereof.
By taking to the
such time, the interim order passed with this court on 13th January 2014 will continue. What's the next matter?
All these matters that relate to the same case, all purchasers.
All right.
Of
In view of
86.
the order
order
passed
to
on
be
this court today in 22642 of 2013, the impugned orders in these writ petitions are also set aside. And all the corresponding revision cases will now be listed before the AD Bhubaneswar on 10th April 2023, on which date the petitioners will appear along with downloaded copies of this order. The AD Bhubaneswar will proceed afresh in the matters and pass appropriate orders.
Now it is
within a
before
period
your,
of 4 months.
it is before your lordship Tahsildar Bhubaneswar.
No.
ADM has
ADM.
Oh, like.
Divisional authority.
Till such time, status quo shall be maintained. All right.
Item number 55.
My lord, what is the date I have to appear, your lordship?
10th April.
Within 10 days.
10th April.
10th April. Lovely. Urgent copy of it.
Item 55.
Well, item 55, the list shows my learned senior has filed a counter.
But all right, tell us what the matter is.
Well, here, my appeal has been dismissed on the ground of limitation. My consistent case is, my lord, in any of the proceeding, I was never noticed. When I came to know, I filed an appeal. The appellate court dismisses my appeal, saying that 30 days time was there to file an appeal and you have not filed within 30 days, so it is to be dismissed.
When did you file it? What is the date?
My lord, I filed in the year 2013.
No. What was the extent of delay?
My lord, delay is 26 years.
26 years?
Yes, but my lord, I was never noticed in any proceeding. My lord, no notice was given in the proceeding, in any of the proceeding. I was never noticed. It was completely, I was unaware of anything. And that I have categorically mentioned in my application. My lord, if I'm not a party to any of the proceeding, my lord, how will I know about any proceeding being held? Neither my vendor was noticed, nor I was noticed.
You got under registered sale deed?
Yes, I got under registered sale deed.
Who's for the complainants?
Well,
Who's for the opposite parties?
3 to 15.
3 to 15.
I am appearing for opposite party 1 to 3.
1, 2, 3 is neither here nor there, sir.
Sorry.
No. 1 and 2. 3 to 15 is what we are talking. Have they been served?
3, 4, 5. I am appearing for 3, 4, 5.
3, 4, and 5.
No.
So what do you have to say if he's not made a party? If he's a subsequent purchaser, should he not be heard, sir?
But, actually, he is not connected with this land
Why?
because original land ex-intermediary.
He's the subsequent purchaser, sir.
My lord, original ex-intermediary has leased out this property to my vendors and they sold it to me. And 5I proceeding under OEA Act was initiated against the leaseholders.
But he's also a purchaser.
And he says that
Maybe the man sold it to both of you.
My lord,
When vendor sold both the parties. My sale was prior, his sale was later, and he got it settled. I filed an appeal that I should be heard.
No. Please,
I was not heard.
I may be permitted, my lord. My vendor has got 9 acre 92 decimals of land and he claims 1 acre 35 decimals of land. My case was adjudicated threadbare and on the basis of challenge and deposit of the year 1944 and 1945, I got the lease. His case is that in 1946, he got the lease after the cut-off date, my lord.
Who's in possession?
My lord, I am in possession.
His vendor's vendor.
No, who's in possession?
My lord, I am in possession.
1 minute, sir. Let me check.
His vendor's vendor.
Who is in possession, sir?
Possession. Possession, my lord. I am in possession and I have.
See?
And in the settlement proceeding, my lord. What is my feeling? This is a fit case to relegate the parties to the civil court.
That's what.
Because there is a rival claim over in respect of a particular piece
But
of
the
land.
appeal out of the original proceeding is staring at me. So unless it is said, I've given an opportunity of contesting the appeal, but that will stare at me and civil court cannot have a right to decide this. It can decide possession, but it cannot declare my right because 6-7 proceeding is there in. Again,
Now he says, my lord, he has not been noticed. He has no knowledge. After 26 years, he has knowledge. But in the settlement revision, he was a party. He has engaged lawyer, and he has said that.
Can you make an inquiry and tell us who's in possession?
Lord, this is a private dispute between two.
No, you are very much there, sir.
No,
ultimately, the orders are all being passed by your officials.
As a authority,
find out who's in possession. Maybe neither is in possession and somebody else is in possession. Today we pass an order. Somebody will come tomorrow and say, no, these two gentlemen have sold it to us.
Again, another.
It's very likely.
Moreover,
these are all Bhubaneswar or Bhadrak, isn't it?
No, it is not Bhubaneswar.
Right.
Had it been Bhubaneswar, I would have so many persons.
Never know who's in possession, who's got.
After that, my lord, some persons have been dead at the opposite party. No substitution has been taken. And some other person, those who say that they are the necessary parties, they have not been made parties.
All right. Both the petitioner as well as respondents 3, 4, and 5, opposite parties 3, 4, and 5, claim that they are the lawful purchasers of the property at, where is it located? Plot number? No, in Moza Gailpur under Tauzi number 1547 of an Anabadi Khata number 658, plot number 1966, acre 9.92 decimal. And that each of, and in fact, and that each is in possession. Full stop. These claims are obviously at cross purposes. Full stop. The court would require the
Tahsildar to
Tahsildar Madhav Nagar. What is this?
Bhadrak.
Bhadrak. Additional Tahsildar Bhadrak, or this Tahsildar Bhadrak, to conduct an inquiry by personally visiting the site and submitting a report to this court as to who's in possession, and in the official records who's shown as the owner of the property in question. This report be submitted before the next date, list in the regular bench, in the regular list, whatever, on July 5th. Interim orders to continue.
Obliged. Item number 56.
56, my lord, no instruction.
No instructions dismissed.
Item number 57.
Yes, my lord. I mean, permit to withdraw with liberty to file appeal provision there. OGLS Act.
All right, counsel, the petitioner seeks leave to withdraw the present petition, liberty to file an appeal against the impugned order. In terms of the OGLS Act, this post office withdrawn with liberty is prayed for. The appeal is filed not later than 3rd April, accompanied by an application for condemnation of delay, explaining the pendency of the present petition as the reason for the delay. The appellate authority will consider it in accordance with law. The court clarifies it has not expressed any view in the matter. If the appeal is filed within the time stipulated, accompanied by an application for interim relief, then till such time an order is passed thereon by the appellate authority, the interim order passed by this court on 10th April 2014 will continue. The petition is disposed of, is withdrawn with liberty is prayed for in the above terms.
Item number 58. It I am the opposing party.
None appears in the petition. Dismissed.
For the petitioner. My lord, actually, Vesco has been taken over by Tata Power right now. So due to the change in management, we have not been able to take instruction as per the present. So
we'll just say that no instructions dismissed. As and when you get instructions, you revive it. All right.
Item 59.
In my lord, no instructions.
No instructions.
60 is my lord, covered by that ASO Sardas, my lord.
Narottam Brata. 60 Narottam Brata.
Much of
Kota Narottama, 60.
60.
Item 61.
my lord, this matter is infructuous.
Dismissed as infructuous.
Item 62.
My lord, item number 62, my lord. As in the meantime, my lord, the retrenched workman has been re-engaged through outsource on contractual basis and they are continuing till date. As to which, my lord, section 25F is not applicable and the matter has become infructuous.
All right. It is stated that the matter has become infructuous. It is disposed of.
My lord, that may be recorded, my lord. They are still continuing.
Not, we'll just say you're saying it is infructuous. That is enough. Oh, yes.
My lord, at least liberty may be granted to file fresh cause of action if.
But no need for liberty, madam. Yes.
Item number 63.
None appears dismissed.
Item number 64.
May I please, Lord? My lord, the petitioner challenged the order 27/12/2012, my lord, against the order passed by the Law and Labour Code, my lord, Jaipur, my lord, in which the retirement benefit, my lord, that about rupees 2,73,512 has not been given to the concerned petitioner, and the prayer of the petitioner is rejected by the Law and Labour Code, my lord. That is Annex 2, my lord.
Was there an award? Prior to this 33C2, was there an award, sir?
No. That is when the retirement benefit, my lord. After.
There must be a determination, sir. Only then 33C2 will come in.
My lord, actually, after retirement, my lord, he had, that is.
So you must raise a dispute, you must get an award. Then for implementing that award, you can go under 33C2. Without determination of that dispute, you can't invoke 33C2 directly, sir. That's the law. It appears that the workman has filed the present petition challenging an order dated 27 December 2012 of the Labour Court, Jaipur, rejecting the petitioner's application being industrial dispute miss case number 9 of 2010, filed under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 bracket ID Act. Paragraph, after his retirement from the respondent 1 OFDC Limited, the petitioner filed the above application for a sum of rupees 259,935 towards ex gratia and leave encashment. Full stop. The fact of the matter was that there is no prior determination whether the petitioner was entitled to the above amount by means of a separate award of the labor court. Full stop. Therefore, it was doubtful whether an application straightaway raising such a claim could be maintained under section 33 capital C bracket 2 of the ID Act. Paragraph. Nevertheless, even on otherwise, the labor court has found that disciplinary proceedings had been initiated against the petitioner for causing financial loss to the tune of rupees 428,038 and a penalty for recovery of 437,237 was imposed on the petitioner by an order dated 26th April 2007. Stop. This was not disputed by the workman. Stop. Procedure for recovery was already initiated against the workman. Stop. It was rightly observed that those proceedings could not have been challenged by the workman in proceedings under section 33 capital C bracket 2 of the ID Act. Paragraph. Having heard learned counsel for the petitioner and having perused the impugn order of the labor court, the court is unable to find any ground to interfere with the said order. The writ petition is accordingly dismissed.
Item 65.
None appears dismissed.
Item number 66.
May I please? My lord, that is covered by Narottam Ratha case, my lord. That is the order of settlement option.
66.
All right. All right.
Item 67.
Lord,
67.
The grievance, Lord, total boils down to the issue as to payment of ID cost, infrastructural development cost. Here, your Lordship will find, I have a small list of dates and friend is giving to your Lordship. Yes. Petitioner's husband was an applicant for a plot in the GA under GA department, my lord. By the time allotment was made, the husband was dead. Lord, page 11, Lordship would kindly see the allotment order. Though it is the name of the petitioner, husband, but the husband was no more there. But allotment order applied in the year 1981, allotment in the year 1992.
Capital, new capital Bhubaneswar.
New capital.
What is the value today?
Lord, I'm not disputing the value. Lord, I am on some other point. Your Lordship will kindly see what is the issue here.
First of all, are you in possession or you're not in possession?
Lord, they have not given me because of the non-deposit of ID cost. They have not given me.
Okay.
Lord,
and you got an interim order here.
Lord, I got an interim order. Lord, I only say, Lord, my limited prayer before your Lordship would be, Lord.
Yes.
The manner of calculation of the ID cost so far as the defaulters are concerned, that is completely, Lord, irrational. That your Lordship, I can so demonstrate to your Lordship, Lord. I can demonstrate that. And in that view of the matter, I am not asking your Lordship to calculate that. Lord, I'll obviously seek a liberty from your Lordship to approach them to recalculate it. And till that date, let the protection be there.
That's a good point, sir.
That otherwise, Lord, my value of right goes away.
One factual submission. My lords, this petition, my lords, this is the second round litigation.
Now, my lord, the first round litigation.
Can I just, before my learned friend, can I just explain that from my side? Let your lordship see, my lord, what is the issue here? Now, they allotted me in the year 1992. My husband was dead. I applied for mutation. Lord, on the issue of legal heir certificate, they rejected, they did not allow my mutation. I came before your lordship, my lord. This honorable court dismissed my writ petition. Kindly turn to page 35, my lord. This honorable court dismissed my writ petition, saying that this legal heir issue and other issues, kindly see page 35, order is there. This honorable court dismissed my writ petition, saying, same lord, the documents do not disclose material fact. After receiving those facts, they will take steps, but the petitioner has not taken steps. After receiving the said information, 2 years thereafter, the petitioner have come up with the present petition seeking relief as aforesaid. Petitioner residing in West Bengal, so they, without complying with the terms and conditions as stipulated in the allotment order, have approached this court at a belated stage. Therefore, we are not inclined to entertain the writ petition. Dismissed. It is dismissed, madam. Now, thereafter, the GA department show moto, just flip over the next page, page 36, just flip over the next page. Page 36, 2014, GA department themselves mutated the land in our name. So my cause of action arose afresh, pursuant to their own action. 2014, they allowed mutation in my favor, accepting my legal heir status. Kindly similar page 36. So dismissal of the writ petition will will obstruct on my way to get my rights settled with them. Page 36, kindly similar. They mutated it in my name, Aloka Gupta, the present petitioner, son so and so. This is 2014 after dismissal of the writ petition. Now, kindly similar, in the year 2013, they themselves revised their guideline. Lord, I am asking benefit of this revised guideline only. Kindly see, my lord. Page 39, para 6. Just this paragraph I'll show, my lord, nothing more.
But I don't know how you did not avail of this. What is the extent of, what is the size of the plot?
Lord, size of...
It is
60 to 90, no?
60 by 90. 5,400 square.
Wow.
No, but I'll tell you a lot. See, the premium I have paid, entire premium I have paid, they have received.
It's 2.5 crores.
No, my lord. Premium at the cost that they demanded from me, my lord, in terms of the allotment order, kindly see page 11. 55,786. So that I paid within the time stipulated, man. So that's paid.
That's 32 years ago, sir.
But they are not, Lord, after they have accepted the premium from me, my lord, kindly consider, my lord, I have their term of their lease deed condition is after they execute the lease deed, I am supposed to pay the ID cost.
Yes.
Lord, I have paid the premium to them.
Yes.
They have accepted the premium from me, my lord.
Yes.
And thereafter only they will execute the lease deed.
Yes.
And I am supposed to pay the ID cost.
Yes.
Now your lordship see the receipt I have said that I have paid the entire premium to them within this period of 120 days. One just clause your lordship may kindly see that 2013 revised guideline, my lord. I am coming out of that only. Kindly similar page 39.
Yes.
Clause 6. This is the only clause I will show, my lord, and I request your lordship to consider this, my lord.
Yes.
For cases where allotment orders have been issued,
yes,
full premium has been paid within 120 days, which I have done. From the date of issue of allotment order, lease deed formats have been supplied for execution, but the allottees have expired. Not my allottee has expired. Without executing the lease deed, and legal heirs now want to execute the lease deed. The legal heirs, successors of the allottees shall be allowed to execute the lease deed by cut-off date, that is by 31st of March 2014, on deposit of differential premium at the prevailing rate and revised ID cost at 2.5 crore per acre in one installment within 90 days from the date of information, failing which allotment shall automatically stand cancelled.
Yes.
Now, my lord, I am ready and willing to comply with this term. I have paid the premium in full. My lord, only just see, my lord, the manner of their calculation, my lord, what they have done.
Yes.
Page 48, my lord. Page 48, the way they are demanding ID cost from me.
Yes.
My lord, they have an allottee of, kindly see, my lord, they have allottees total
Mr.
of...
Ratha, I don't know what your financial capacity of your clients are, but it's a gold mine, sir. It's a gold mine.
Lord, may I pray, my lord? Lordship may permit
better to stay off than if you're not able to afford this for a Bhubaneswar plot. Don't aspire for it.
Lord, may I request, my lord? Your lordship may permit me. I'll approach them to work
but
out.
no interim order, sir.
They will allot it in favor of some other person, my lord. But then in that case, Lord, your lordship may give a 1 month time to them. Lord, let it be just Lord, calculated. Whatever comes out of that.
It will be much more, sir, now.
No,
may I make
in 2013, you are required to pay 2.5 crores per acre. Now it will be much more.
Lord, only your lordship may permit me. I'll raise this issue before them. Lord, let them recalculate. I say that this is, my lord, unconscionable. Because the whole expenditure they have incurred towards ID cost of 2,700 allottee They are now realizing from us.
This whole litigation is speculative, sir.
But I can understand, my lord. Your lordship may see, if they would be rational enough, kindly see, my lord. Lord, they have total allotee of 2,007. Lord, their own calculation, kindly see, my lord, what they have done. Page 48, what they are doing is 2,700 allotee. There are defaulter of 200 numbers defaulters out of them. They are realizing the whole ID cost of 2,700 allottees from these defaulters, 200 people. That is what they are doing, my lord. That is how the ID cost has increased. Otherwise, my lord, it will at best come 20 lakhs per acre. Now they are charging 2 crores per acre. In this manner, they have done page 48 manner. So that's the reason, my lord, Lordship may allow me to, my lord, raise my grievance before the government, my lord. I'll raise all these issues before them. Let them at least take a conscious decision on my grievance.
No, sir, not inclined. You say the challenge the present petition.
My lords may see my counter affidavit, which I
You're
find.
dismissing.
Lord, may I suggest?
If you want to say something more, we'll pay.
Lord, may I suggest, my lord? May I suggest?
Just,
Lord, I'll pay the demanded amount, man. Lord, I'll pay, Lord. I'll abide.
my lords, that is why, my lords, I was pointing out my counter affidavit, because in our counter affidavit, we say that the letter, the 42 lakh letter was inadvertently.
He's not paying that amount. He says whatever is due as of today.
I'll pay.
No, my lords, he's not, because that policy, my lords, it says that in 120 days, my lords, you have to do certain things. He hasn't done it, so he will not even get the benefit. And therefore, my lords, my lords, also the single previous litigation, there was a particular declaration to be given that this person should be a permanent resident of Odisha. That, my lords, is not there because they have been staying in West Bengal. So as per, my lords, the allotment rules, my lords, they are ineligible.
I see.
My lords, that, my lords, will file at page 34, my lords, of the order.
I see.
Not a permanent resident, 5 years residence period.
It says he's a permanent resident of Odisha and has resided.
Lord, I'll pay. Let them.
But it's not just about payment, sir.
These are ineligibilities.
Lord, 2014, they have themselves muted it. Kindly see, man. They have corrected my name in the records. Kindly see, Lord, page 36. But this proposition is not available to the state. They have done it, already allowed in my favor. Kindly see page 36, Lord.
But it's strange that after that you were still asking them to deposit 42 lakhs.
We have said that, and we have tendered unconditional apology for sending.
You are the ones who gave them hope. And then you accepted the mutation, you granted that also.
Yes.
All right. All right. The writ petition is dismissed. We'll pass the detailed order. Dismissed.
Item 68. Item number 68.
If I may please your lordship, I'm appearing on behalf of my learned senior, Mr. Bhuya. Your lordship, we have entered appearance as the petitioners as well. Lordship, this case pertains to a property which is claimed by us to be a private walk-off property. Lordship, under the section 3 of the Act, and we are claiming to be the successors of the said Peer Syed Kalandar Badshah.
Who's for your opposite parties, sir? 3 and 4? Who's appearing for them?
3 and 4, your lordship.
3, no, not just 3 and 4, no? Yeah, 3 and 4. No. Large number of opposite parties. 3 to 13. Who's appearing for 3 to 13? And then Waqf board also has to be heard, right? Oh, where is he?
Opposite
Mohammed
party. No,
Azad.
2 is the contesting party. 2.
Let it stay on board. So let them come. Without hearing them, can't decide this matter.
Much obliged.
Item 69.
I may be permitted to place it on behalf of Mr. Mohanty, Onimus Mohanty. But a piece of land of which I am owner and the record of right published in 1977, a portion of which has been encroached by the for construction of road and block. Now, I filed a suit in the year 2004. Pending that suit, the Tahsildar called upon for negotiation. And they negotiated to exchange a portion of government land which is adjacent to my land in lieu of this property which they are using, portion of the land of they are using. So accordingly, a joint inquiry was conducted. Your Lordship kindly come to page 13. In view of the positions, the owner of the private.
No, but what happened to that other land now? By now that.
That is exactly that. So the exchange case continued, and in turn it is submitted to the collector and then to Revenue Divisional Commission. These are being recommended in my favor to the government. Now, pending that.
No, for exchange, you're exchanging some other plot for this, correct?
The mine land, they are taking the road. And
what are they giving you in exchange?
The Gochor land. That's so that is
the road has already come up in our land.
Yes, my lord.
There was some status quo order. How come?
No, my lord, it is prior to that. They have all first done. Then I went to the civil suit, and pending that civil suit, they accepted the exchange proposal. They constructed it. Then
this is already infructuous.
No, my lord, they are the exchange case. What is my case is that the portion of land. In any event, in my land, if they are using, they have to pay me the compensation, or in lieu of that, they have to give the exchange land.
No. Exchange land you already have, you say?
No, my lord. The exchange land was the proceeding was initiated. This proceeding has come to up to the level of RDC with all recommendations.
No. When this court passed an order 18/8/2014, status quo as on today over possession of the petitioner in respect to the land in question be maintained. What does it mean then?
That is that the exchange land they have given possession.
So you are in possession
of that land, yes.
Let's get the facts clear. So the exchanged land has been given to you, you're in possession, but you simply want ROR to be changed.
Yes, madam.
You apply for that.
No, that they are not finalizing the proceeding. That is what the issue.
There's a slight issue here, in a counter affidavit, the issue is that he had that land. And thereafter, 1977, there was a settlement. And we found out that actually in that settlement, he had fraudulently introduced his name in the records. And it was actually in possession of a person named Bhagavata. I'll just read the name. And then OEA proceedings were there, and he was the ex-intermediary. He had given that land.
So whatever it is, you pass final orders. That's it. Whatever you have to pass final orders. Yes. If you have to deny him, pass final order and be done with it.
If they deny me, insofar as my land is concerned, they have to pay me compensation.
He just says you pass final orders. Why are you keeping the matter pending?
And if they deny, now they're in the counter denying me to grant me the exchange, then they have to pay me the compensation. Now in 2000,
no, they'll pay whoever is the owner of the land.
I am the owner. That is not.
That we don't know because he's disputing that also.
Yes, no, that they dispute. 1977, the ROR is published.
All we can say at this stage, because we've seen the prayer, you only want the proceedings to be finalized.
Ex parte, I can show your lordship that is 1 year period is the limitation given under the Act. That is filed 1977 is the ROR has been published.
Anyway,
in 2012 they filed.
Yeah, only grievance in the present petition is for a direction to opposite parties 1 and 2 open quotation to take a final decision in exchange case number 8 of 2008. And court considering the proposal submitted by the RDC CD Cuttack. Paragraph. While directing notice in the present petition on August 2014, this court directed status quo to be maintained as regards possession of the petitioner in respect to the land in question. Paragraph. It is accordingly directed that if no final order has yet been passed by OP number 1 in regard to the aforementioned exchange case, then such order shall be passed positively on or before 1st May 2023 and be communicated to the petitioner within a week thereafter. Full stop. Till such time, the interim order passed by this court will continue. Stop. If the petitioner is agreed by such order, it will be open to the petitioner to seek appropriate remedies in accordance with it. The court clarifies it has not expressed any view in the matter.
Item number 70.
If I may be pardoned, Your Lordship, item 68 interim order may be extended.
They're not passing the orders, it's just on board. Yes.
Item 70.
I'm sorry, Your Lordship.
None appears dismissed. Both matters.
Item 71.
This is covered by Your Lordship's judgment in Narottam Rath case.
All right. Narottam.
Item 72.
In fact, the grievance is with regard to non-payment of compensation. The OP number 2 is dead. I have filed one interim application that is at flag A, my lord, with regard to making a prayer for impletion of parties. But then yesterday my instruction was that they are trying to compromise, settle the matter among themselves. So either Your Lordship may dispose of the matter saying that the parties are.
All right. Mr. Rathe points out that as regards the grievance made in the present petition, the parties are
exploring the possibility
of settling it inter se amongst themselves. The parties, that is the petitioner and opposite party number 2 and the legal heirs of opposite party number 2 are seeking to settle the matter amongst themselves. In that view of the matter, the court is not inclined to pass any orders at this stage. The petition is disposed of.
Right. Item 73.
I am for the opposite demand, my lord.
None appears to the petitioner dismissed.
Item 74.
24, my lord, I am for the opposite party. Counter not filed, my lord.
My lordship, they need to file a counter, my lordship.
No. What's the matter about?
My lordship, actually, they have challenged the order of the learned court below, my lordship. My lordship, kindly have a glance to the order, page number 26, my lordship. My lordship, the issue was that whether the fixation of the scale of the pay of rupees 2,774 to 4,724 for the dispatcher with effect from 1/4/97 by the management of RHEP OHPC Rengali White order number 110405. And the finding is, my lordship, to issue number 1 is, my lordship, in the case the second party union claims the scale of the pay of rupees 3,600 to 6,550 for the post of diarist cum dispatcher under the OHPC with effect from 1/4/1997 instead of the pay scale of 2,770 to 4,724. Admittedly, the Balimala hydroelectric project is providing the scale of the pay of rupees 3,600 to 6,550 to its dispatcher. But here, my lordship, the learned court below has not given the detail of the order because, my lordship, in our written notes of submission, which we have filed as Annexure 1, my lordship, we have written that after the OHPC formed, my lordship, he has his own rules and regulation. And as per the rules and regulation, my lordship, we have all the category of the people, like any 1, any 2, and any 3, 4, 5, like this. My lordship, these people are the diarists and they are for the any 3 category. So their fixation of the pay is, my lordship, uh, 2,770 to 4,724. Because, my lordship, after they come from the government, my lordship, what they are getting much higher from the OHPC, my lordship. That's why, my lordship, the the learned tribunal has not given in his finding the detail of the order and only just passed the award that both in the second party union claimed the scale of pay 3,600 to 6.
I think the ground is just come to page 30.
Yes, my lordship.
This Balimela hydroelectric project is also your project, right?
Yes, my lordship. Our project.
There, in that project, you are giving the higher pay scale to dispatchers.
My lordship, they are any 5 grade, my lordship, because under the government they are working in a higher pay scale, so they are getting 3,600. But these people are this union have filed particular for one person, my lordship, and he is getting, my lordship. I have already annexed, my lordship, and my lordship kindly have a glance to page number 21.
Only one person. You're fighting this one person's salary.
My lordship, the union has filed for the one person, my lordship. Yes, my lordship.
Why should you contest this one person's salary?
Because my lordship, what
will happen? Nothing.
What happened? There is only one, my lordship. One post is vacant for the dispatcher. Any 3, my lordship. And my lordship, another thing is they have come before this honorable court, and honorable court has given the direction to file a representation before the authority, and they have already disposed of the representation. They have never challenged that representation, and now they filed before the labor court, my lordship, for the higher pay scale.
Rejection of representation doesn't mean that they cannot challenge.
Yes, my lordship, they can challenge, but it cannot go beyond the rule and regulation which.
And this they is a problem. There's only one person.
But my lordship,
we're only talking of one person.
Yes, my lordship. But my lordship, kindly have a glance to page number 21.
What is that age of that one person, sir?
My lord,
you are representing that one person.
My lord, that the union peoples of the post of dispatcher. My lord, the fact is like this, my lord.
1 minute, sir. Why don't you answer the question?
My lord.
She's talking of only one dispatcher whose cause you're espousing.
My lord.
That one dispatcher, what is his age today?
Age of the employees, my lord.
If you say dispatcher.
I can repeat.
Yes,
my lord, may I respond submission?
Age of the employee.
Age of the employee now they are continuing, my lord. They're more than 55, 56.
That only diarist.
My lord.
What would be his age now?
60 years, man. 60 years is that retirement age.
So why do you want to pursue all this? We'll leave the question open.
My lord, the background is, my lord.
1 minute, sir. We are trying to pass an order in your favor. If you're going to stop us from passing an order in your favor, I don't know what advocacy this is. We want to dismiss her petition. And you still want to argue, sir?
No.
My lordship, kindly have a glance, 1 minute glance for page number 21.
60 years old, and this is one employee. We leave the question open. In some future case, you can take it up. All right.
My lordship,
the
they
challenge
will
of the present petition is to an award.
Demand from 97, my lordship.
Sorry?
1997, my lordship. They will demand.
What?
That pay scale, my lordship.
Madam, this plural singular is your problem. Same problem for him. One, according to him, is many employees.
No,
for you, one means they.
Sorry.
So, my English gets very seriously questioned. Sometimes I begin wondering whether I have to go and relearn my English.
Page 27 is your answer.
21, my lordship.
27, the question.
The challenge of the present petition.
Yes, my lordship. That the answer, my lordship, we have written.
Only dispatcher, that's all.
Only dispatcher. And in page number 21, we have already clarified how much that person was getting from the government and how much we are giving him.
Anyway, all right. The challenge of the present petition is to an award dated 21st March 2014, passed by the Industrial Tribunal in Bhubaneswar. In industry dispute case number 3 of 2014, answering the reference made to it in favor of the workman and against the management. Paragraph. The following reference was made to the tribunal for its determination. Take from page 27, top paragraph. on formation of the Orissa Hydro Power Corporation Limited (OHPC), the Ringali Hydroelectric Project, which was earlier directly controlled by the state government, came within the administrative control of the OHPC. Along with it, the Balimela Hydroelectric Project, which was under the control of Orissa State Electricity Board, also came within the control of the OHPC. Paragraph. The present case concerned the pay scale payable to the single quotes dispatcher, unquote, employed in the Ringali Hydroelectric Project. Good stop. His claim was that there should be a parity of the pay scale given to the dispatcher of the Balimala Hydroelectric Project. Which was rupees 3,600-6550. Full stop. The case of the workman dispatcher was espoused by the OHPC Employees Union, bracket, opposite party number 2, bracket. The case of the OHPC was that prior to absorption of the RHEP, there were two separate scales. That is NE2 and NE3. Stop. As far as the dispatcher in the present case working in the RHEP is concerned, since he was drawing the NE2 grade scale in the government, it was contended that he was not entitled to parity of pay scale with the dispatcher engaged in the Balimela Hydroelectric Project. Paragraph. The Labour Court appears to have rejected the above plea by observing that for the same scale, for the same post of dispatcher in two different units of the OHPC, there cannot be two different pay scales after the units were absorbed in the OHPC. Paragraph. Apart from the fact that this is a plausible view to take, the court finds that during the pendency of the present petition, the diarist cum dispatcher in question is neared the age of superannuation, and it is an individual case of one person, since admittedly there is a single post of dispatcher. Paragraph. In the circumstances, while clarifying that the impune award of the Industrial Tribunal will not constitute a precedent for any similar claims in future, the court is not inclined to interfere with the impune award. Stop. Interim orders vacated, the petition is disposed.
Item 75.
My lordship, 75 is also same matter, but here the person is Ferro Printer. He is also, my lordship, from
Single
NEC.
person.
Yeah.
All right. Same order. We just have to change the post. All right.
Item number 76.
Lordship, 76, no instruction.
No instructions.
Item number 77.
My lord, Mr. Rath is on his legs. Let it be on board.
Right.
Item 78.
May I pledge your lordship, my lord? The matter relates to my lord. The OPLE proceeding has been initiated against the petitioner, my lord, and the revision has been dismissed by the RDC, a collector, my lord. My lord may kindly see the Annexure 5 at page, my lord, At page 48, it is the land situates in the township of Sambalpur, my lord. My lord, may kindly look at the annexure 5, page 48. May I place, my lord? It has come to the notice of the Department of Tahsildars are initiating eviction cases under the provisions of Odisha Prevention of Land Encroachment Act 1972 for eviction of encroachers from public premises as dependent under the Odisha Public Premises Eviction of Unauthorized Occupants Act 1972. The matter was examined in concerned law department. The word public premises has been defined under Section 2F of OPP-EUO Act, which means any premises situated within the jurisdiction of municipal council or NSC or within an area declared by the state government to be an industrial estate and belong to or taken on lease by the state government, etc. As per Section 2 of the above Act, premises means any land or any building or any part of
this order of the collectors. You can't go further in appeal, is it? Under the
No.
OPP Act.
No, we have already gone in revision. That is revision.
He is coming against the revision.
Beyond that,
RDC.
RDC.
Oh,
so here the my lord, OPP-EUO case
Where is the
has been
RDC
initiated by the authority, but it is not been initiated. So they have started OPLE case. We challenged it on the ground of this plea also, but they rejected it.
Where is the RDC's order, sir?
Annexure 3, my lord.
Annexure 3 is the collector's order, sir.
No, the collector is the regional authority, my lord.
Sorry?
Collector is the regional authority, my lord, in this OPLE proceeding.
No, against that, there's no further.
No further, my lord. Read this.
Yes, this is revisional. Revisional authority.
The revisional authority, my lord.
Page 34.
So already it went back. But earlier the RDC Sambalpur was asked to rehear the appeal.
Rehear the appeal, my lord. After rehearing only, this has been heard. And thereafter, we challenged the order, which the claims were not considered by the authority. In High Court, my lord, thereafter, this Underwood Court directed that eviction proceeding be initiated against us, without considering that our 55 years of possession over the said land from the lessee, my lord. It's a leasehold land. The case, my lord, is like this, my lord. The case land was, my lord, the third generation lessee Jogendranath Sen, my lord. My lord, he became the member of Johnson, and the Johnson office was started there, my lord, in 1967. My lord,
may I submit one thing?
My lord, may I submit? May I submit thereafter, my lord? My lord, thereafter, my lord, he died. Thereafter, her wife and daughter were the party they belonging to party of Johnson, and they continued, my lord. In the year 1986, my lord, and by that time, my lord, they wanted to transfer the land to the BJP office, my lord.
No. Who wanted to transfer the land?
The Shobha and the Sandhya Sen and Shobha Chakrabarti.
No. So is there a document of transfer?
My lord, which document? Transfer? No. My lord, they asked the collector, he was the approving authority, said that it may be transferred to Johnson office because the other approaches.
Ask meaning what? They gave a letter or what?
They have given the letter in the 1960s, my lord.
Where is that letter, sir? Show us a copy.
We don't have, my lord. We don't have this letter, my lord. Thereafter, they said that collector said that we have to file the lease application for the land, my lord.
No, but unless you show a letter, sir, unless you show that letter of 1963, where do you get a locus to file an application?
No, my lord. We filed the legislation in the lease application, my lord, separately.
On what is the locus to file it?
My lord, we are in possession, and the two ladies, my lord.
That's the whole question, sir. This is exactly the point here.
My lord,
question.
My lord, let us have a pause, my lord. Thereafter, my lord, what happened? After that, 1986. The collector took the vacant land, and thereafter, the next day, 27, 1986, 50 decimals of land, and we are occupying only 60 decimals of land. Thereafter, the collector 21/7/1986 recommended the case lease renewal in favor of Sobha and
1 minute, sir. 1 minute.
May I submit one thing? To
You better examine if you can regularize this.
No, one thing I mean.
If there been occupation since 86.
High Court, pursuant to the order of the Honorable High Court, the proceeding was initiated under the OPLA Act. Admittedly, it is in the Anavadi Khata, recorded owner is the government. Now he is saying by virtue of certain documents, that is 1966
No, he doesn't have the document.
No, that is what I am saying, that we have got subsisting right over the property in question.
So,
if your lordship can relegate them to
Annexure 2 and Annexure 1,
because it is a case where they claim that we have got title over the property, which cannot be decided in a OPLA proceeding. OPLA proceeding, it is very confined to the record of right, and
P number 4 is the successor of the original lessees.
That is what I am saying.
OPLA case cannot be continuable.
Apparently, you are very magnanimous, sir. You very happily gave it to the party. That's what they say.
No.
Yes.
It has not been
You have a very large heart. That's what Mr. Hota is
It has
saying.
not been given.
You're very large-hearted. You gave it to us, he says. In fact, he gave it to the Jansang, he says. In 1963 itself, no, sir?
My lord, 1967.
So
that
your
is
large-heartedness goes back 50 years.
Like that.
Your lordship can take up the second matter. For a very noble cause. For a very noble cause.
Your lordship can take up the second matter, it will be made clear.
My lord, it has to be settled.
The property was the original lessee was there.
Yes.
Lessee, during his lifetime, we were in a portion of the property. The lessee did not renew the lease. Lessee left that place. They forcefully entered that premises.
No. It's not correct. We are in possession since 1967. They are also the party.
Government has sent, and we are in possession of the rest, some portion, and my vendor's great granddaughter is in possession of certain property.
My lord, may kindly see, my lord, I may be.
Eviction proceeding is there also.
Against them, not
My lord, eviction proceeding cannot stay, cannot continue because of the OPPU Act. Annexure 5
because
is
they are in unauthorized occupation.
Yes.
They claim that we have got subsisting title, which is adverse to the title claimed by the opposite
Eviction proceeding is there against them, staring at them. Eviction order.
No, my lord. OPLA proceeding is not maintainable.
Not maintainable.
The OPPU Act to be maintainable. That after, well, the government, and this is, my lord, kindly see Annexure 1. What is it, my lord? Annexure 1 at page number 17.
But what I find interesting, Mr. Hota, is,
my lord,
in your petition, you don't implead them. In their petition, they don't implead you.
It doesn't matter, my lord. Doesn't matter. Because we are a party, my lord. We are national party. We are having office since 1960 Johnson days, my lord.
Correct.
We are continuing with the possessions, my lord. We have applied for the lease, but it is not considered. It was rejected by the RDC earlier.
There are also 4 other writ applications.
That the enclosures backside, my lord.
Pending, it's not before your lordship.
My lord,
I see.
Yes.
4. Which are those? Tell us.
No, that is tagged, my lord. All enclosures are tagged. All the cases are tagged, my lord.
No, there are many other cases by my senior. The original.
Give us that.
Granddaughter.
More the merrier now. Yes, give us those numbers. Writ petition civil, give us those
numbers. Those are actually the original lessee. Have filed an application. Why is the matter remanded by the Honorable High Court?
I know.
But they say
it's now incapable of further remands.
They are actually approaches.
In my case, your lordship will be inclined to remand it because your lordship may see my WPC number 1051 of 13, page 48. This Honorable Court directed that to consider my lease application afresh. The RDC said, no, because I have decided against you, I will not reconsider it.
Yes.
And he sits over your lordship's judgment.
Yes.
Otherwise, my lord, may I suggest, my lord, your OPPU Act be initiated afresh after the resumption of the land from the private parties. But Annexure 1 is completely clear, my lord. They have already sold out. The land is sold out, not in government.
No, first, Mr. S.P. Mishra is working hard to expand this batch. He's giving us more numbers.
He is a failure candidate, my lord, appearing for the failed
He is an encroacher. He has encroached upon the land which has been rezoned by the government.
I may be encroacher. I am encroacher by
But I am the
1955.
actual possession of the property, of some portion of the property.
Yes, we have only some possession property. You are not in possession, but you have sold out.
All right. So all your gunpowder, keep it dry. 4 more matters. We're just asking them. It will stay on board. Just make sure these 4 matters come. All right. We'll show you.
Tomorrow.
It will be on board, sir. It will be on board.
When it will come, madam?
So that
And then
your,
we fix-
your
then we
guess
fix-
is as good as mine, sir.
When the days be fixed.
Let it come next week so that we can.
Other copies, my lord, I have not been served with.
Ah.
Stay on board.
You will see those matters, then you will see the name of the council in those matters, then you will call up those council. All that will happen. All right.
No, interim order to continue.
In 105,
interim order to
my name
continue.
may be reflected.
Interim order to continue.
No orders are being passed, sir. We're just asking the registry to send those numbers and show those numbers. Right.
Item number
In
79.
1051, my name may be indicated so that I will not miss the list.
We've said that. The registry will be told.
Item number 79.
None appears dismissed.
Item number 80.
Same order.
Item number 81.
Same order. 82, same order.
Cyclist 82.
Same order.
Item 83.
Same order.
Item number 84.
Meet Visual Lordships. I am appearing on behalf of Mr. Sambit Mahanti, counsel for the petitioners, my lords. The present application has been filed back 2014, in which the petitioners were sought for a direction in directing the opposite parties to release the amount that was awarded in their favor and by order dated 13/8/2010 by the Special Land Acquisition Officer Jagat Singh Puri. My lords, we seek the amount to be released in our favor.
You have to approach the Special Land Acquisition Officer. You say the limited prayer in the present petition is for release of the land acquisition compensation. Full stop. Said to be due to the petitioners. Full stop. The petitioners will approach the Special Land Acquisition Officer cum sub-collector Jagat Singh Puri along with all the relevant papers and appear at 11 a.m. on 3rd April 2023. After examining those documents and papers, an appropriate order will be passed by opposite party number 2 within a period of 2 months thereafter. And the order will be furnished to the petitioner within a week of it being passed. No further directions are called for at this stage. The petitioner is passed.
Item number 85.
None appears dismissed.
Item number 86.
Memo taken on record.
Item number 87.
87, actually after 22 years, 38B has been invoked.
Oh.
There are a number of judgments your lordship delivered also. The delay is one of the factors why it should not be interfered.
No, but on the contrary, your lordship has passed many judgments where 38B has been invoked after 30 years. And
Sukinda.
In that case,
This is
your
that
lordship
Sukinda. Sukinda is a separate category.
the petitioner to file civil suit to declare his title.
But that actually, if your lordship can, that's a general order that your lordship passes. But after 22 years, my lord, if somebody has already right has accrued in
But you will anyway be in possession, sir.
Yes, we are in possession.
No, I'm saying when you file the civil suit, it's not going to change.
Delay is one of the factors that your lordship may also consider. 22 years.
So the allegation of fraud in all these
No,
cases.
they use the same words everywhere actually, without any material. They use the word fraud and say that it takes away all the limitation. Here actually the
Actually, in this case, Mr. Mishra, in this case, there doesn't seem to be any interim order. No interim order in this case.
No, but we are in possession. They have not taken possession.
So you can then go to the civil court, sir. You say the challenge.
Here, possession has not been taken and they are continuing to possession.
So then you agitate your rights in the civil court. You say, while the court is not inclined to interfere with the impugned order of the Board of Revenue, passed in the present case, the court nevertheless leaves it open to the petitioner to agitate his rights in appropriate proceedings in the civil court.
To establish his occupancy rights.
Okay, to establish his, permits to establish his rights, title, and interest in appropriate proceedings in the civil court.
Right.
The petition is disposed of. Right.
Connected.
Say.
Item 88.
Item 88, my lord, because of the subsequent development, your lordship. In fact, this petition has become infructuous.
All right.
Your lordship,
Petition has become infructuous on account of subsequent developments. It's disposed of. All right.
88. Liberty that may be lordship.
Not necessary.
Item 89.
89 matter, no instruction matter.
No instructions dismissed.
Item number 90.
All right.
90, my lord. I file a case for withdraw the application as it is an appealable under section 127 of the appellate authority before the election.
All right. Counsel of the petitioner seeks leave to withdraw the present petition with liberty to file an appeal in accordance with law. Disposed of is withdrawn with liberty spread.
Item 91.
I pray this may stay on board for Monday, but there is need of some regulation. 2 orders have been passed in respect of the same order, which has been challenged, and this court has been pleased to quash the proceedings. But unfortunately, there is some problem which needs to be regularized. I pray may be taken up on Monday.
All right.
Item 92.
92, my lord. The 13th notice was challenged, but I am told by my learned friend appearing for the bank that account has been closed by now.
All right. Since the account has been closed, nothing survives the matter. The petition is disposed of.
Item 93.
Your lordship, I am appearing on behalf of Mr. S.B. Jana. Your lordship, in this matter, the petitioner is praying for the reinstatement and the payment of full back wages. Your lordship, kindly turn to the page number 23, where the Law and Labor Court, dealing with the issue number 1, what observes. The first party, the para 8 of the hour. Para 8 of the hour.
Yes.
The first party management having suppressed material documents to rebut the claim of the second party workman. This court, on the basis of the evidence adduced by the second party.
They paid you this 2 lakhs or not paid you?
They have not paid me, but I am praying for the reinstatement.
First of all, let's get them to pay you the 2 lakhs at least, sir. Why are you depriving your client of that?
I'm praying for the...
You don't have to give up your claim, sir. I don't think you're listening to what I'm trying to tell you. Are you listening to what I'm trying to tell you?
Yes, your lordship. But that is only compensation. But
so we're not saying that we will not entertain any other plea of yours. You've got some little relief from the tribunal.
Yes, your lordship.
We want you to first get that relief, and then we will consider all your other prayers for the other reliefs that you want. Is that okay, or you have a problem with that? We are saying, apart from making sure that we'll give you the 2 lakhs,
yes, your lordship.
We will then consider your plea for full reinstatement, full back wages. You have a problem?
No, your lordship.
How many? 3 thrice I have to explain to you. Who's appearing for the management? Who's appearing for the management? Have you taken notice? Yes. Second copy not filed. 715. One, Mr. Do you know who's appearing on the other side, sir?
No, your lordship.
Why not? Always, sir.
It is old matter.
When I was a lawyer, I was very keen to know who the other side lawyer is. Without that, I know I will not get relief. Suppose I go to the judge and somehow, in the absence of that lawyer, get an order, I know it will get set aside by the next court in 2 minutes. So I'm very keen to make sure that the other lawyer is present. I don't think it's an advantage to say quietly, let's get an order when the other lawyer is not there. Disaster. First ground of appeal will be, in the absence of the other lawyer, the order was passed. So go find out your counterpart. We'll wait. We'll keep the matter on board. Make sure that your counterpart comes to the court. His name is there. Please check out where he is and tell him that the matter is being called out. All right. Yes.
Oblige, your lordship.
Item number 94.
I praise your lordship.
In the read petition, my lord, I have wrongfully, my lord, typed my lord, plot number which has been acquired at 2654, that is 2659. That's why I permitted to withdraw, file a better petition with better
All right.
particulars. my lord.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a better petition with better particulars. Disposed of is withdrawn, liberty is free.
Any liberty.
Item 95.
95, my lord, covered by lordship judgment Narottam Ratha.
All right.
95 and 96.
All right. Narottam Ratha. All right.
Item 97.
May I please kindly pass over for the day, lordship?
All right.
Oh, please.
Item 98.
None appears dismissed.
Item 99.
None appears dismissed.
Item number 100.
None appears dismissed.
Item 101.
101 is also covered by Narottam Ratha, lordship.
All right.
But the petitioner has died in the meanwhile. So we have filed an IA for substitution.
All right. That IA for substitution, give us that application. That's taken on board, allowed, and then Narottam Ratha. All right.
Grateful.
All right.
Item 102.
My lord, item 102 and 103 on behalf of Mr. P.K. Jana, we are for OP2.
So none appears to the petitioner. Dismissed for non-prosecution. All right.
Item 103.
Same.
Item 104.
104, may I pray for tomorrow, stay on board? I'll do it, ma'am.
All right.
The friend who has authorized is somehow absent.
All right.
Item 105.
None appears dismissed.
Item 106.
None appears dismissed.
Item 107.
My lord, I am for the opposite party on behalf of Jay Patnaik.
All right. None appears to the petitioner dismissed.
Item 108.
Memo taken on record. Dismissed.
Item 109.
None appears dismissed.
Item 110. I am for the opposite party number 1.
Okay. None appears to the petitioner dismissed.
My lord, I am appearing for the petitioner, my lord. I am praying for Passover for the day on behalf of Mr. S.D. Das, my lord.
Or it will stay on board, sir. All right.
Man, obliged.
Item 111. 111.
None appears dismissed.
Item 112.
May I please, your lordship? My lord, here the petitioner challenged the order dated 31/12/2014 passed in the ID miss case number 25/2010 by the Labour Court. When the petitioner claims that the Labour Court doesn't have the jurisdiction to pass the order. My lord.
Your lordship, on behalf of Mr. Mishra, I pray for a Passover for the day, your lord.
Stay on board. All right.
Much obliged.
Item 113.
None appears dismissed.
Item 114.
Same order.
Item number 115.
May I please? This is arising out of a Orissa Hindu Religious Endowment Act. Mr. Nath is appearing for the commission, endowment commission.
I'm appearing on behalf of OP3, lordship.
The endowment commission is the
Miss Naidu normally appears, no?
Yes.
Miss Naidu and Mr. Nath also appears.
Then let's wait for them. He'll stay on board.
Item 116.
None appears dismissed.
Obliged.
Item 117.
No instruction, lordship.
Memo. Yeah, no instructions dismissed.
Item 118.
My lord, in 118, the petitioner is already died. We'll file a substitute petition, my lord, in the meantime, 2 weeks' time. Maybe.
Does the cause of him survive? What's the matter about?
I'm telling the resumption of leasehold property. The petitioner is a power of attorney holder.
Or you stay on board, sir. You file that application. You stay on board. Okay.
Item 119.
That appears dismissed.
Item 120.
My lord, I pray to withdraw this matter in liberty to approach the authority.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the authorities in accordance with law. Disposed of is withdrawn with liberty.
Item 121.
No, I may be pardon, my lord. Item number 116, my lord.
Passed over?
That has been already been, my lord, settled between the parties, my lord. And I am giving another writ application. Both the writ application may kindly be disposed of.
Or give us the number. You said other one taken on board. Ms. Mahapatra informs the court that the issues have been already settled between the parties.
That is, my lord, WPC number 10837 of 2015, my lord.
Okay, 837 of 2015.
10837
of 2015.
My lord. Both the
So
matters
both petitions are accordingly disposed of.
Disposed.
All right.
Item 121.
None appears dismissed.
Item 122.
None appears dismissed.
Item number 123.
123 may please. Limited grievance balance that money honest or 7 balance by OTS application for settlement of the loan account of the petitioner. Base 36 that was pending for the opposite was 1 balance.
Who's for the bank, sir?
The bank counsel has not appeared balance.
No, has notice gone to the bank?
The notice has not been gone. It is a first time balance.
How can it be, sir? After 7-8 years, how can it come for the first time? By now, everything will be over, sir. By now,
one instruction, the council, the opposite party council has not bank appear malicious.
No. How will he appear? No notice is issued, sir. How will he appear?
Even notice will be called malicious.
No. Not after 8 years. We're not issuing notice for the first time after 8 years. You say permitting the petitioner to seek other appropriate remedies as may be available to the petitioner. Court of law, the petition is dismissed.
Item 124.
None appears dismissed.
126.
May I please submissions? Sure, in item 126, I'm asking the cancellation of my lease order dated 3/9/2015. The lease was in respect of a plot where I have constructed and running a nursing home, namely Jeevan Rekha Nursing Home. And the lease has been cancelled by the government, Your Lordship. I'm asking that. The government has not filed its counter yet. And before the Human Rights Commission, they have admitted that there is no apparent violation on my part, Your Lordship.
No. One thing is, you're using the ground floor for residence and running a nursing home with the first.
No, Lordship, I was not using that for a residential purpose, Your Lordship. I was a treating physician. I was the owner of the nursing home.
No, this was only a show cause notice, is it?
Yes, Your Lordship.
Yes, sir.
You replied to it?
I replied to it, and they've inspected where on the date when I was not in the state, Your Lordship, and they've issued the cancellation order. Lordship, the state government himself before the Human Rights Commission.
How is the Human Rights Commission to do anything with all this?
Lordship, they have themselves admitted that there is no apparent violation on my part. Lordship, may permit me one day, I'll bring those documents on record, Lordship.
Stay on board.
Next.
Lordship, adjourning this matter?
Not adjourning, it will stay on board. Better bring those documents now.
Your Lordship, may call it on Monday so that I can file. Much obliged. Your Lordship, there is an interim order.
We're not passing any order, madam. Yes.
Much obliged.
Item 128. 128.
One product I am for the petitioner. In full order is at Annex 5. Challenging.
Who's for the respondent? Mr. F.R. Mahapatra. Mr. M.K. Panda. Let them come, sir. Stay on board.
Item 129.
129. My lord, I am the petitioner. The lordship may kindly see challenging the award passed by the labor court. The lordship may kindly see I have filed the balance sheet of the corporation, my lord, and there was a loss of 50 crores, my lord, in the year 2002, my lord. However, the decision was taken to downsize the size of the staff, my lord, and as per rule 38 of the TDCC employee rules, my lord, the service books of the employees were reviewed, my lord, and 21 employees, your lordship may kindly see, have stated in para 4, my lord. Those who have completed 20 years of service or attained the age of 50 years, their services were reviewed, and the petitioner along with 21 employees, my lord, they were given compulsory retirement under the rules, my lord. Your lordship may see the rule 38 of the employee service rules, my lord.
We'll continue tomorrow.
And your lord,
We'll continue tomorrow.
My lord.